Hello there. Your Honor, this is Amos Washington before the court on 21 CF 2413. Who is going to appear for Ms. Glisson?
I am covering for her.
Okay.
She advised what your intentions were, and we have no objection.
Okay. Yeah, we are going to be requesting a continuance, Your Honor. As you know, I am relatively new on the case. I did have an opportunity to meet with Mr. Washington, and we have begun the process of going over things and going forward on the case. We have run into an issue with some of the downloads, and Ms. Glisson and I are supposed to have a meeting tomorrow to see if we can kind of work through that.
What do you mean by
We're not able to view all the downloads. So, and that is it's a huge part of the case from our point of view.
And what aren't you able to view? Documents, videos, like what kind of stuff we talking about?
Yes, it is. It's all it would be the cell phone downloads from their correspondence back and forth and Facebook and things such as that.
When that cell phone download comes through, does it come with its own program that?
Well, and it depends. And so this time it's the Cellbrite. But normally the sheriff's office does the download, and it's Casey Campbell, as I'm sure you're aware of, that does that process. This time, this is a different person that has done this, and it's just, I'm not tech savvy, but I've had others, including our tech department, and they said there's not enough there to be able to work through it, and so that's why we've sort of reached this issue. But we do have a meeting scheduled for tomorrow to see if we can work through that. We do have some additional depositions set for the end of the month, and we are going to be doing some other things as well.
You said, so depots in next month, May?
So we have a few depositions that are set for, yes, sir, the end of May.
All right, Mr. Washington, I know this case has been pending for quite some time. Any concerns? Obviously, Ms. Rivers is new to your case based on your previous counsel is no longer working in this division. Any concerns from your side? Because I know there was a kind of a Nelson hearing that we had talked about last time, but you said you were okay going forward now with Ms. Rivers, now that she's on your case. Any issues you want to bring up? Okay. Thank you, Mr. Washington. We'll see you back on June 24th.
Oh.
Just, I guess, to talk about, I don't see that we're at the need where we should just say PD starts at 1 o'clock on the incarcerated days, but obviously, y'all don't need to be here at 9 if you're not going to get to your cases until at least 11, 12, 1 o'clock. I mean, if y'all want to start talking about just changing it to 1, we can do that, but yeah, I know it's been my experience in talking to everybody that y'all just want to get going as fast as possible, so I'm not trying to make that kind of separation, but at the same time, I'm always wanting to do what's beneficial for you all. All right, go ahead.
Your Honor, this is Derek Lewis before the court, 23 CF 2797. Your Honor, this is a new case to me. I did just take over this case. I have met with Mr. Lewis twice. It's my understanding there's an FDLE report outstanding. Once that comes back, I believe that we'll be ready to have our final conversation and decision as to whether to go forward or accept the state's offer.
On the DNA,
Yes, Your Honor.
Yes.
The FDLE on the DNA that was requested by the defendant. Yeah.
we just did the buccal swabs, I think, last time.
But I've been following up with FDLE, so it's under my radar to get it done as soon as possible.
This case is pretty old, too. I know it's new to you, Ms. Rivers, but let's see what we can do to get it done. June 24th, 9 o'clock.
Thank you, Your Honor.
And I'll be Your Honor, this is Diane Malone, 21 CF 923. Your Honor, the previous status of this case is the previous counsel had filed a notice to seek insanity, and the state then requested their own evaluation to be done. I know Dr. McDonald has done the evaluation. I saw her at the jail. We're just waiting for the report. And
That's correct, Your Honor. I received information from Dr. McDonald telling me that she has seen and met with Ms. Malone, and she has requested and still waiting on the mental health records from the jail. This is Dr. McDonald's email to me. And that was sent to me this morning at 5 a.m. So
we're going to be requesting a continuance, Your Honor.
And Ms. Malone just got back here, right?
That's correct, Your Honor. She has been away.
All right, Ms. Malone, we'll see you back on June 24th at 9 o'clock. Obviously, we're going to talk about that evaluation once it's been finished up.
Okay,
All
thank
right,
you.
thank you.
Macauen.
Your Honor, this is Jared Macauen. He, 24 CF 2665. He was previously out. I happened to notice that he was showing up on the docket as being in jail, so I went to go see him. And he is in now on another case. I did meet with him this week, and we're going to need to watch videos together to decide how to proceed on the case. I know he was talking to me about wanting to file a motion to suppress.
All right, so there's the new case, which is not set for plea date until the 29th of May.
Yes, sir.
Go ahead and put them to June 24th at 9 o'clock. When we get here on May 29th for the arraignment date, we'll put them all together.
I can. Your Honor, this is William Cochril Moore. He's before the court on 24 CF 2085. We've reached an agreement in this matter.
All right, thank you, Ms. Rivers.
Here.
What are we doing with count two?
Your Honor, count two would be plea as charged.
Okay.
Count one is plea to a lesser.
I was a little confused because it says count TO and then it says PAC, and I'm like, that plea as charged is, I guess I've just never seen PAC like that before, so, but count two. All right, so it's 11 months, 29 days jail, waive all prior credit, so 11/29 from today.
That's correct, Your Honor. That would allow him to complete the ECLC program because he's already been in eight months.
All right, but it says then 18 months probation, and it says he will be allowed to enter Haven House to complete that, but I'm not ordering that he do so. Just as a condition of probation, he's allowed to go to Haven House. Okay. All right, Mr. Moore, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Moore, can you state your full name and date of birth?
It's William Cockrell Moore. It's July 28, 1985.
And based on the reduction in charge, this is a guideline sentence, correct?
Yes, Your Honor.
Okay. All right, so Mr. Moore, you're here currently charged with burglary of a conveyance while armed, which is a possibility of a life felony. Also carrying a concealed weapon by a convicted felon, which is a second-degree felony punished by up to 15 years in state prison. I've been handed a plea and sentencing agreement that would have you plead to a lesser included on count one of trespass, which is a first-degree misdemeanor. And then that'll be just adjudication of guilt and credit for time served. And then on count 2, you'll plea as charged to 11 months, 29 days in jail, waiving all your prior credit. Complete the ECLC program while in jail, and then you'll complete 18 months of probation. During that probation, you'd be allowed to, but I'm not ordering you to, do Haven House to complete their program. Waive cost of supervision, court costs are $415, $100 cost of prosecution, $100 PD fee, and $50 application fee. Is that your understanding of the agreement?
Yes, sir.
Is that the state's agreement?
It is, Your Honor. It's the
Okay.
state's agreement.
All right. And Mr. Cockrell, did you go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir, I did.
Are you satisfied with your attorney's
Very much
advice?
so, sir.
All right. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
Sir.
You understand by entering a plea there won't be a trial of any kind?
Sir.
You understand you're waiving all potential defenses that you may have?
Sir.
And did anyone force, pressure, or threaten you in order to get you to enter this plea?
No, sir.
Anyone promise you anything in order to get you to take this plea?
No, sir.
Do you understand without the trial, you're giving up all your trial rights, which are listed on page 2 and on page 1 and going on to page 2 of the agreement you signed?
Sir.
You understand that you're giving up your trial rights that are in the agreement? That
Yes,
you-
sir. Yes, sir.
Okay, sorry. And do you understand that this is an adjudication of guilt, so you'd be a convicted felon based on this?
Yes, sir.
And do you understand that if you're not a U.S. citizen, you could be deported due to this?
Yes, sir.
Okay. Got to ask everybody.
Yes, sir.
All right, so what is your plea to the lesser included trespass and carrying concealed weapon?
No contest.
I'm going to accept your no contest plea to the lesser included offense of trespass on count 1, adjudication of guilt, credit for time served. And on count 2, that's as charged, carrying concealed weapon by a convicted felon. It's going to be punished by 11 months, 29 days in the county jail, waiving all prior credit to today. You're going to complete the ECLC program while in jail, then complete 18 months of probation. You'll be allowed to enter Haven House to complete their program, waive cost of supervision, $415 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee. Gain time. Is that going to get him out faster than he can complete the program?
He's already completed the first 90 days.
Okay,
Yes, sir.
perfect. All right, anything that I've missed? All right, Mr. Moore, you have 30 days to appeal the judgment and sentence of the court, and you have to talk to probation real quick, even though you're going to be in jail for the ECLC program.
Yes, sir.
You need to talk to probation, because you're going to be on probation once you get out, and then I need you to be fingerprinted as well before you
Yes,
leave.
sir. Yes, sir.
All right, thank you,
Sir.
sir. And this
I think
is
they want you to go
guideline
there
sentence
first.
Based on the charge reduction.
Your Honor, this is Shane Morrow before the court on 21 CF 2674, 21 CF 2998, 22 CF 273. This, I have met with Mr. Morrow. We are going through his cases. We're not ready to set anything at this time. We are going to request a continuance. Just for the court's recollection, this hasn't been in the division sitting here since 2021. This is something that has come back.
That's without objection, Your Honor.
And what did it come back for? What was why did it come back?
Your Honor, this was the council that originally had it, plea agreement to everything. But then on appeal that was filed by Mr. Morrow, the court felt that there might have been a source of conflict potentially between counsel and the defendant. And because of that appearance, they're back to.
I remember that one now. It never went to the DCA, right? It was was it something that came back before it ever went up?
Honestly, I don't exactly recall that.
I don't want to confuse it with another case. It doesn't really matter, I guess. I just try to remember this.
I believe it did go to the DCA, but
Okay.
I don't want to be quoted on that. But I do know that they felt that he would be allowed to withdraw his plea. So that's what we did.
Okay. All right. So we're going to come back on June 24th at 9 o'clock on Mr. Morrow's cases. Obviously, Ms. Rivers is working your case now. I know we talked about that last time, that you were okay with that, right, Mr. Morrow?
Yes, sir.
Okay, perfect. All right, then we'll see you back on that date, and Ms. Rivers will come out and talk to you.
Thank you. Thank you.
Your Honor, this is Jared Mullis before the court on 24 CF 2840. I have now met with Mr. Mullis. We have gone over his case. He had wanted to watch some of the videos. We've now watched the videos. So the next step will be, if we so decide, and once we have a further discussion as to whether we'll do depositions, but at this time, we are going to request a continuance.
All right, State, any objection to the continuance? Is it Ms. Leone's case?
It should be, yes, it should be Ms. Leone's.
I don't believe there's an objection.
Okay, thank you. June 24th at 9 o'clock, Mr. Mullis. We'll see
Thank you.
then on that.
Thank you, Sergeant.
Hi, Miss Purple.
Hello there.
There you go. That's for
Okay,
you.
okay.
Did you get it? It's kind of a repeat. I wanted to make sure you got it.
Your Honor, this is Kenneth Osborne before the court on 16 CF 1542. This is a case that also had come back. Your Honor, Mr. Osborne last time had requested a number of transcripts. They just came in. There is one other issue that has yet to be resolved. If I may approach with the state?
Yes.
I'm going to talk about Mr. Moore.
Please see. Yes.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
All right, so Ms. Rivers, get me an order regarding that evidence, and I'll certainly take a look at that. Make sure you send it in Word format in case I want to change any of the language or anything.
Yes, sir.
And then I'll get that back to you. But do you have all the transcripts that Mr. Osborne was asking for?
Yes, Your Honor.
Okay. All right, so we'll put it on June 24th at 9 o'clock.
All right.
See you back on that day, sir. Thank you.
Thank you, Your Honor.
He is going to do the order. Your Honor, this is Desmond Porter before the court on 25 CF 137. I have met with Mr. Porter. We have begun to go over the discovery. There was not an offer on his case at the time that I spoke to him. I have spoke to Ms. Basso today. I will need to meet with him to go over that offer because it is a DOC offer.
What are you asking for then?
624, please.
June 24th. at 9 o'clock will be your next court date, Mr. Porter. Obviously, if you work out anything else, you want to get it back sooner, you can do that.
Yes, sir. Your Honor, the next one on the docket, we did do a motion to continue. You did indicate that you still wanted to hear about what was going on in the case.
Specifically on his, I thought I continued it.
You did, Your Honor.
Okay.
Okay. I just wanted to make sure.
Yes. Because you filed them, after we said something about it, you filed a motion, I saw that, and I granted
He
it.
signed it, yes, sir.
Okay.
Your Honor, the next one is Bradley Simmons, 14 CF 2669, 24 CF 2626. Your Honor, we're in the process of negotiations with the state. We're going to ask for the next court date of 6/24 at this time.
Objection.
No objection for the state, Your Honor.
He hasn't come off anything. I asked him a
24th, 9
while ago.
o'clock. Mr. Simmons, we'll see you back on that date.
And this week, this month.
No, you got June, so you got a month and a half.
And obviously, if y'all work out something different, and you want to bring it back sooner, you can find a date.
And Your Honor, before they go to the next person, but after Mr. Simmons, we did skip Kenshan Scott.
Thought so.
That is 23 CF 936. He is in DOC. My understanding is the state was waiting on autopsy results to decide whether to upgrade the charges.
Yes, Your Honor, we don't have that yet. We don't have the autopsy results yet.
Okay. It's my understanding he's doing a life sentence in DOC already.
That's correct, Your Honor.
All right, June 24th.
Your Honor, the next is Kenneth Singleary. He's before the court on 25 CF 230. Your Honor, I have retained an expert on this issue, so we are not ready to go forward at this time. I have given the state copies of all the classes that you have done, okay?
Well, I want to say something to the court.
Okay, just don't talk about the facts.
I ain't talking. I want to address the court.
Okay.
But I want to put it on record that I gave my attorney a motion that I want her to adopt.
Okay.
To file the motion on my behalf. I don't need to come to the county judge and talk to them about the situation.
Okay.
But what did the next court
And I
do?
did. COs.
I don't care nothing about that. I need you to file that motion that I filed.
So
To adopt that motion.
there's a problem with the motion, the way it's written, so we'll have to talk about it, okay?
Write it. They can come up with it soon.
All right,
Kinda
and
jealous.
Yeah, I
Mr.
will.
Singleton, just to put on the record, I know you filed a motion yourself. but
Right.
you're let me finish. You're represented by counsel, so anything that you file is a nullity. I mean, if you filed something regarding what your attorney has done, that would be different, but she has to approve it or not.
Right.
And if she feels there's concerns that they're not, that it's not a valid motion, or
She can adopt it and refile it.
she can,
Right.
but she also has an ethical obligation to the Florida Bar not to file things that she doesn't believe are good faith motions. So y'all can talk about it and see if you can work out something as far as what you think is the proper strategy, but ultimately she has an ethical option to the court and to the bar to not file anything that she doesn't believe in.
Right, I understand that, but she's representing me as a representative, and it's a valid motion if she adopted, and I needed to know.
She hasn't done that.
Oh, okay, well, that's what I need you to do. I need you to adopt that motion.
Well,
to
and what I'm
refile
explaining
for
to
me.
you, Mr. Singletary, if
Yes,
she
sir.
doesn't believe it's a valid motion, if she doesn't think it's legally sufficient, then she can't file it.
I understand that. I understand what you're saying.
I just want to make sure you understand, because I
Well,
saw the
well,
motion. I'm not going to give an opinion on it, but obviously, again, it's a nullity because you're represented.
Right, but it can be adopted.
It can be, it has not been.
Yes, sir, I understand.
And I think I've hinted enough as to maybe why.
Yes, sir, I understand, but you come
All
to
right.
the.
So I'll let y'all talk about it, but then we'll come back on June 24th.
All right.
Your Honor, before the court is Julius Sledge, 24 CF 2745. Last time we were in court, Mr. Sledge had indicated he was retaining his own counsel, private counsel. I've met with him once since then when he had requested that I bring him up at the jail. There was really no conversation, only just to give me a little bit of information. So that's where we're at on this case.
Mr. Sledge, are you hiring someone else?
They won't let nobody see me. They ain't let nobody see nobody out there. It's hard for the people to see people. They won't bring me down. It's documented, trying to get it all together, but yeah, more than likely.
So you're saying that you've tried to get an attorney to come see you in the jail, and the jail's refusing to let you see them?
She'll tell you herself. They're not letting nobody see people. They came up there the other day to see me and turn them around. They've been turning them around since the day I come in, before I even came back here.
Where is this?
I was able to see maximum security people last week, but I've not been able to see maximum security people this week. And I know Mr. Russell as well. All day,
Is there an
nothing.
explanation for that?
The same explanation that has always been given for the 13 years I've been here.
Okay, which is what?
Understaffed.
Well, defendants have a constitutional right to meet with their lawyers.
Your Honor, last time I felt like it, when I felt like it was potentially hurting my client, and I had a court date coming up, I just started notating the dates and times to prepare to file a complaint with the appropriate people at the jail. But then they brought the person, so it resolved itself.
Is it a situation where you can kind of schedule it in advance, or?
And that may be something that we bring up to see if that would make it more agreeable to them.
Well, I'd like to be kept in the loop on this because, and frankly, I'll probably end up talking to Judge Stone and Judge Clark about it as well, because if it's going on in their divisions, people have to see their lawyers.
It's quite troublesome, especially when their people are facing life.
What?
So what do we want to do today?
Your Honor, I would request a continuance to 6/24.
Right. Well, I'd like to hear more about if there are further issues. Ms. Rivers, Mr. Sledge, anybody that wants to tell me about, being prevented from seeing their lawyers. I mean, I'm pretty sure the Constitution still says you have a right to have a lawyer and you have a right to due process, and I'm not sure what the situation is.
If you don't mind, can I ask you a question?
Well, I probably can't give you the answer you want, but go ahead.
Okay, so this attempt on here,
We're not going to talk about the facts of your case.
Oh, okay. Oh, you know it.
It's not my first time, Mr. Sledge.
Okay, but
I can't give legal advice, number
that's
one.
all right. That's understandable.
And two, if you talk about the facts of your case, everything in this room is recorded.
That's
and
what
it
I
can be
need to
used
be.
against you. Obviously, there's 4 prosecutors sitting here who would love to write down whatever you say that could be detrimental to your case, so I can't allow you to talk about the
But
facts
it's
of it.
not detrimental. It's just the word.
You may say that, but it's kind of, you ever hear you can't put the toothpaste back in the tube once it's out? All right. So, obviously, if you're going to hire someone else, tell that person to talk to the jail. You want to
But
see.
she has. She's writing it down. They won't. Even though she set up the thing, they tell her to come the next day. They send it to my family. Say she'll be there the next day. They still not letting her see. She's supposed to came Tuesday. They still not doing it.
Well, I'd like to hear about this on a more systemic basis, what's going on, not just your case, Mr. Sledge. Not to say yours isn't important. They're all important. That's why I want to know how widespread this is. I mean, is it just with Max? Is it everybody it's more difficult with?
Everybody.
I'd like to know, and I'll talk to our administrative judge about it to see if there's anything that can be done to push that issue, because it certainly doesn't need to be that way. But, I don't have the ability to tell the jail what to do, but I can certainly tell them when they're not doing it right if something is brought to my attention. All right. Thank you, Mr. Sledge. We'll see you back June 24th.
Your Honor, this is Derek Smith. He's before the court on 25 CF 319, 24 CF 966. I have met with Mr. Smith. We have been going over the facts of his case. We're going to request a continuance to 6/24. This is relatively new, maybe the first time.
It's kind of hard to hear. There's a lot of, go ahead, Ms. Brewer, I'm sorry. It's just-
Yeah, Your Honor, I have met with him. We have gone over the facts of his cases. It's relatively new. We are going to
Hold on a
request
second. Open the door,
continuance.
Sarge, and that seems. It's amazing that it's hard to hear people who are right here, but it's very easy to hear the people who are behind that, very thick wall. I'm sorry, Ms. Rivers, go ahead. I want to hear what Mr. Smith's case is all about, but I could not keep that out of my head while it was going on.
Your Honor, we have met, we've been going over the facts of the case, these cases, but at this time, we're going to request continuance to 6/24 so we can try to see if we can't work something out with the state that both parties can get on board with.
It looks like there's a brand-new case as far as a new law violation.
That's correct, Your Honor.
All right, June 24th at 9 o'clock. We'll see you back on that date, Mr. Smith. Hopefully we
sir.
won't be so rudely interrupted
That's
numerous
all
times.
right. Thank y'all.
Thank you, Mr.
Appreciate
Smith.
Your Honor, this is Richard South, 23 CF 1796. I did attempt to see him yesterday. He is a maximum security. I could not. As I indicated last week, if I'd known, I would have seen him last week, but just was not able to. We are still waiting on some FDLE, the FDLE to provide the information that was requested, so.
I signed that protective order recently.
Yes, Your Honor, so we're going to request the 6/24 court date.
All right. Mr. South, today's the first day I've heard that there's some issues with y'all seeing your lawyers. I'm not happy about it. I want to know more about it, and see what can be done to potentially fix that situation. But it looks like we're also waiting on some things from FDLE based on the order I signed last month. So we'll have you come back on June 24th, but obviously if you have concerns, make sure they're well known about any issues with the jail for certain. All right, June 24th. Thank you, Mr. South.
Thompson?
Your Honor, this is Joseph Eric Thompson, 24 CF 2424. I have met with Mr. Thompson. The state did just recently give us an offer. In the process of retaining an expert. We're already halfway through the paperwork, so at this point, we're going to request a continuance.
Is that an expert for evaluation purposes?
No, Your Honor, that's in pertaining to the charges.
Forensic?
Yes, Your Honor.
All right, June 24th at 9 o'clock. Mr. Thompson, we'll see you back on that date. Obviously, you heard what your attorneys announced, what they're trying to get done. Thank you.
Hello, Mr. Teladono.
Hey, Miss Lisa.
Your Honor, this is Warren Teladono before the court on 25 CF 392. We just got discovery, as in this week.
It's a brand-new case,
Yes,
right?
Your Honor, and so I believe it's going to be a bit of a lengthy process. We're going to request a continuance at this time.
All right, Mr. Teladono, you understand that?
Yes, sir.
Okay, June 24th at 9 o'clock. We'll see you back on that date. Hopefully you've got some more things to come.
Thank you, Your Honor.
Thank you.
All right.
Thank you, Miss Lisa.
Your Honor, this is Chaitton Trula before the court on 24 CF 60. We have depositions set for May 7th.
Depositions on, you just took over this case, Ms. Rivers?
No, Your Honor. This is my case.
Over a year old?
Yes, Your Honor.
All right. Objections?
We do.
Sure. All right, June 24th.
Thank
See
you.
you back on that date, Mr. Trullo. Thank you. That's just unusual, Ms. Rivers, so.
Your Honor, this is Michelle Ulrich. She is before the court on 20 CF 1718, 20 CF 2285, and 25 CF 303. We have met several times. Yesterday, I showed her one of the videos that pertains to her case. There is no sound to any of these videos. I did send an email to the state asking them to check on that.
We're tracking that, Your Honor. I'm going to make sure that if there is sound, that the defense gets a updated video.
Okay, have you been able to view
I have
/
not
listen to
viewed
it?
the video yet, but I will make sure that it gets out this week, or I'll let them know if there is no sound.
Okay. Is this something y'all are close to a resolution on at this point, or you just need to go over the?
She does want to hear it, Your Honor.
Okay. Oh, no, I just want to make sure as far
Oh,
as, shall we
yes,
see if
yes.
y'all can get it maybe done the next couple days and come back Monday, or?
Your Honor, I think if we just leave it on the 6/24, and if we resolve it before then.
Okay. June 24th, Ms. Ulrich, we'll see you back on that date.
Your Honor, this is Nicholas Wallace, 25 CF 299. I have met with Mr. Wallace. He is requesting a jury trial, so we want to put it on the trial docket.
Your Honor, I'm still awaiting for victims' medical records about the pregnancy. I don't have it yet.
Okay.
Y'all, the state sent them to us.
That was a screenshot. I'm requesting, unless you stipulate to that, I'm fine.
No.
Right, that's what I thought. So we need the certified copy of that image that I sent to Ms. Rivers. And the case is a 25 case, Your Honor.
Yeah, it's a brand-new case,
Yeah.
but how long until you get those?
I cannot tell you, Your Honor, because it doesn't depend on us. We've sent the subpoenas to the hospital. Sometimes they reject it for whatever reason that they have, so we have to resubmit it. I'm not saying that this is the case in this case, but I can check on, I know we sent it.
Thank you.
Okay, so that's the amended discovery exhibit that was just sent over on the 23rd, was the screenshot of it.
Is what the victim has sent me. In the meantime, I wanted them to have it, but I need the certified copy, of course.
So you're asking for a continuance?
Yes, Your Honor.
All right, Ms. Rivers. This the first time up?
It is, Your Honor.
I'm just, obviously, anytime someone's incarcerated, I want to make sure that, and there's a state continuance, I have to look at those things. It's my understanding that his bond, the court revoked his bond in this case based on a new arrest in 25 CF 531.
That's correct, Your Honor.
Was he given a bond on that? Let's see. Which is a total of $55,000 cash or professional on the new case. And then as far as my looking at the dates, this case was initiated February 10th, so 175 days from then would be still past the July the trial dates. So I'm going to grant the state's continuance based on their need to obtain evidence from a third party. And I'm going to set this for June 24th. At 9 o'clock. See you back on that date, Mr. Wallace. Obviously, if anything new happens, you can certainly file anything that needs to be filed.
I was reviewing the notes, and I see a note from this morning. We were advised that this defendant has been placing several video and phone calls to the victim, and she is being frustrated with this behavior. So I'll be filing a motion to revoke bond where he understands that.
In the new case?
In both cases, the same
He's already
victim.
revoked on the old
Right,
case.
then in the new case, of course.
Okay.
Yes, Your Honor.
Well, I mean, I'm not going to say anything to you, Mr. Wallace, other than to state that you've already been ordered to have no contact with the alleged victim in both of these cases. And if you do so, it obviously can lead to the revocation of your bond in the other case, but also criminal charges. So you might want to talk to Ms. Rivers about that. That means direct contact or indirect contact, so you can't tell someone else to contact her on your behalf. Otherwise, you're going to be looking at more charges. Okay?
Mr. Yossi, are you ready? Joseph Riassi for David Bradley in 2024 CF 1841, one count of aggravated battery with great bodily harm. The state had agreed to extend an offer which would allow Mr. Bradley to plead to one lesser included account of lesser included offense of felony battery, which is F3L6, which would lower his score sheet and allow the state to offer adjudication withheld in 2 years probation, a substance abuse evaluation and treatment as recommended, and no contact with the victim, Von Seal, and Treywick, or complete the ECLC. I've gone over that offer with Mr. Bradley, and he's not accepted the offer. He's asked me, he has a bond on the case right now, like $25,000 cash or professional, and he asked me to file a motion to address bond. And I asked him if he was able, what level of bond he would be able to make, and he said he wouldn't be able to make any bond other than ROR. So I told him I would file a motion to request the court grant him an ROR bond. In the meantime, he's instructed me to prepare for trial, and I'm going to do so. So I'm asking the case be continued one cycle.
No objection.
To the next court date.
All right, so I'm going to put it on June 24th. Obviously, Mr. Riasti, if you do file a motion, you can get that set for a hearing. Just so you understand, Mr. Bradley, we can't have kind of on-the-fly bond motions. They have to be filed in writing and put the state on notice. Just like if they were trying to change your bond to your detriment, that you'd have a right to notice as well. So once that gets filed, we'll get that set for a hearing, and then otherwise we'll see you June 24th. All right, thank you.
Thank you.
Kelvin Ford.
There you go. All right, thank you. Sorry about that. All right, thank you.
Joseph Riossi for Kelvin Ford in 2024 CF 765 and 2024 CF 766. I've spoken with Ms. Leone on this case, and she presented an offer. I've gone over that with my client, and he's agreed to accept the offer. It's been reduced to a plea and sentencing agreement with a score sheet attached. It is an agreed-upon downward departure. If I might approach.
State's agreement is 24 months community control when he scores 61.5 months.
Yes, Your Honor, it is.
For the record, Mr. Ford had been vetted for mental health court, and the mental health court agreed that he qualified, but then they said that they stated that he wasn't. They didn't believe he was a candidate for it. So we were trying to have him introduced into mental health court. But based upon that, the state extended this offer. All of his activities have been substance abuse related.
So the state had already previously filed an amended information reducing it from trafficking to controlled substance. All right. All right, Mr. Ford, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Kelvin Lee Ford, 0426, 1999.
All right, and Mr. Ford, you're here in 24 CF 765, charged with possession of a controlled substance, third-degree felony, punishable up to 5 years in state prison, also resisting without violence, a first-degree misdemeanor, punishable up to 11 months, 29 days county jail. Also in 24 CF 766, burglary of an occupied conveyance, which is a second-degree felony, punishable up to 15 years in state prison. And count 2 is grand theft auto, third-degree felony, punishable up to 5 years in state prison. I've been given a plea and sentencing agreement that has you pleading to all of those counts and be given 24 months of community control, followed by 2 years state probation, substance abuse evaluation and treatment as recommended, or the ECLC program, that's Emerald Coast Life Center. No contact with the victim, court costs, cost of defense, and this is agreed upon downward departure based on an uncoerced plea bargain. Is that what you're wanting to do today?
Yes, sir.
All right, did you go over this form with your attorney?
Yes, sir.
Did you understand and sign the plea agreement? Did you understand and sign?
If I might approach you. I had gone over. Yeah.
Mr. Riossi, I think you still owe me page 4. Well, this is for juvenile offenders, he needs to sign that page. All right. Now, Mr. Ford, have you signed the agreement?
Yes, sir.
All right, are you satisfied with your attorney's advice and representation?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Are you sure?
Yes, sir.
Okay, do you understand everything that's going on here today?
Yes, sir.
Do you have any questions?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand that by entering a plea, you'll be giving up your right to a trial and all your trial rights, which are listed on page 2 of the agreement that you've now signed?
Yes, sir.
Do you understand you're waiving all potential defenses that you may have?
Yes, sir.
Do you understand that if you're not a U.S. citizen, you could be deported due to this charge?
Yes, sir.
And what is your plea to the possession, the resisting, the burglary, and the grand theft auto?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. And 2465, possession of controlled substance will be 24 months community control followed by 2 years state probation. We're just doing credit for time served on the misdemeanor.
I'm sorry.
Can we just do credit for time served on the
Yes, yes,
misdemeanor?
yes, sir.
Credit for time served on the misdemeanor, so you don't have to put on the probation for that. On 24 CF 766, on the burglary and the grand theft, it's going to be also 24 months community control, followed by 24 months of state probation. That's all to run concurrent. Substance abuse evaluation or any recommended treatment, or you can, again, participate and complete the ECLC program. No contact with the victim. Is it Chaitton Abram?
Yes, sir, that's the name.
Okay. Court costs, you've got 2 cases here, so that's going to be $615 and $515 for court costs. Cost of defense will be $100 for each case plus the $50 application fee for a total of $250. I'm going to waive costs of supervision due to the fact that you're represented by Public Assistance Counsel. It's a state's agreement to the downward departure.
It is, Your Honor.
Okay. Let's adjudicate all counts.
Your Honor, the statute allows early termination on, for 50% of supervision. In this case, he's got 24 months community control followed by 24 months probation.
Not agreeing to automatic early termination.
I mean, I've already accepted.
Not automatic.
What are you asking for, Mr. Riasti?
I was going to ask that the case be, I guess he would be eligible to file for early termination on 50% of the probation or 50% of the supervision.
Depends on what the law is at the time that you file it. Those laws have changed recently, right, Mr. Riasti? Okay, take a look at them when you feel like filing the motion, but there's no automatic.
I understand there's no automatic, but I'm
What are you requesting from the court?
I'm not requesting anything, Your Honor.
Okay, thank you.
I mean, he can always file a motion for early termination, and then
And that's
we'll
something
consider it.
I can't give any sort of indication of what I would do at that point or when
Right.
it should be
Right.
filed because the law could be different by that point.
I'll file a motion.
All right, thank you.
The appropriate motion at the appropriate time.
All right, thank you, Mr. Ford. You need to speak with probation, then you need your fingerprints done. You've got 30 days to appeal your judgment and sentence.
Your Honor, I think you used the term complete. I think the ECLC prefers comply.
Comply, okay. I mean, it's only a couple letters off.
That's all I have, all I have before you.
Thank you, Mr. Riasti.
Good afternoon, Your Honor.
Mr. Mayor.
I'm asking for a continuance in this case.
Who is this again? I'm sorry.
This is Mr. Landon Blair, excuse me, Your Honor, 25 CF 456.
Just the reason I asked Mr. Maddox is even though if Sergeant Jinks announces that he's probably not getting picked up by the record, so I just want to make sure the name and the case number is on the...
Of course, Your Honor.
All right, thank you, Mr. Maddox. Go ahead.
Yes, Your Honor. It's his first time up. We're asking for a continuance. We didn't have discovery in this case. I've notified the state about that. It will be forthcoming, Your Honor.
Okay. Any issue from the state?
No issues, Your Honor. No objections.
6:24, we'll see you back. Ms. Blair. And Mr. Maddox will come out to see you.
Your Honor, this is first time up. This is Mr. Rocky Carter before the court in 25 CF 263. Your Honor, I'm asking for a continuance. This is first time up.
I want to say something before we get a continuance.
No, ask me first. Your Honor, Mr. Carter's indicated he'd like me to set the case for trial today. At this time, Your Honor, I'm not prepared to do that. I'm still very much so reviewing, discovery, and investigating this case. I've done no depositions. We just received a new victim input statement the other day. If Mr. Carter wants to address that with the court, he certainly can, but I am not prepared to set this case for trial at this time.
Okay. Anything you want to tell me, not about the facts of your case, though, Mr. Carter, but what would you like to tell me?
Yes, sir, Your Honor. May I speak?
I just told you could go ahead. Go, sir.
Okay, I can't hear very well, sir.
Oh, I'm sorry.
Oh, can we get
I'll
him,
make sure.
No, I'm okay. I'm okay.
You sure?
I can hear good enough.
My responses to him, I was not in the microphone, so that's probably why he didn't hear me, but I'll make sure to do that now that you've told me about that, Mr. Carter.
Okay. Yes, sir, Your Honor. My name is Rocky Lane Carter, and I suffer from really chronic epilepsy with grand mal seizures. That's all the dents in my head from having seizure activity, and heart disease. All right, Your Honor, I have gave Okaloosa County and the state of Florida 33 months of my life on just a violation of probation. I was released February the 1st, and I did exactly what CRD told me to do. I went and bought a phone, a bicycle, and went to Helping Hands to stay there. They didn't have a bed, so my sister let me stay there. My sister has dementia and Alzheimer's, and she's 85 years old. She's very difficult. I did not want to stay there, but CRD made me stay there. So this case is insufficient and incorrect with the charges. I'm just trying to say I can't take another blow like this. I'm not going to live 10 more years. My neurologist and my cardiologist said I'm on death's bed. I'm not pleading with the court on that, but it's true. I am 66 years old and I'm falling apart. No men in my families live past my age. And I'm pleading with the court, no continuance, and take it to trial a trial because it's just incorrect, Your Honor. I was only out 2 days. And
Mr. Carter, don't talk about the facts of your case.
and I'm just,
Just so you know, Mr. Carter, everything that's said in this room is recorded, so if you talk about the facts of your case, the state will be able to use those against you.
well, there's nothing to use against me. Everything I say is correct.
Okay, I got that. But
And,
I can talk to you about some of this, but
And all I need to do is go to Bridgeway and get my medication. I'm on severe medication. I take about 1,500 milligrams a day just to keep my seizure activity, my blood rolling in my heart. And jail and
Just
prison.
so you understand, Mr. Carter, you're currently charged with a third-degree felony battery, which is punishable up to 5 years in state prison, and a first-degree misdemeanor assault on someone over the age of 65, which is a first-degree misdemeanor punishable up to a year in county jail.
And
what that means is if you were to go to trial and your lawyer's saying he's not prepared due to the fact that this is a very new case, he hasn't received all the discovery yet, that if you go to trial and are convicted, you can get 5 months in prison.
And for the record, Your Honor, the offer that I am aware of from the state currently is 36 months DOC.
Is that a guideline sentence, or?
I've never laid
No,
my.
Your Honor, well, I mean, a guideline technically, yes, but he scores 17.550 months. So, I mean, I understand Mr. Carter's concerns, but again.
That means if you go to trial and are convicted of the felony, I have to give you at least 17 months in Department of Corrections unless you're able to convince me for a reason for a downward departure.
But Your Honor, this is my sister. I never laid my hands
Don't
on
talk about
her.
the facts of your case.
I never laid my hands on anybody.
Don't talk about the facts of your case, Mr. Carter. Please.
Now, I had trouble in court before with Mr. Timothy Gibbs. He
He's not
was
here
no
anymore.
good.
He's not here anymore.
Forgive me, Your Honor, unless he has anything further, I mean, I've
Well, I've got to make a determination as to whether or not I'm continuing the case.
understood, Your Honor.
I'm here just to clean my slate. I never laid my hands on anyone. I never touched
Mr. Carter, today's not.
I've been locked up for 33 months.
Okay.
And I've never done anything to anybody.
All right, so what you're saying is you don't want the case continued even though your lawyer's telling you he's not going to be able to be prepared.
From the record of the year 23, I never touched anyone and I got 30 months.
All right, you want your trial? I'll give you your trial, Mr. Carter. I think you need to talk to your lawyer about it and see what can be done.
I'll talk to the
certainly
lawyer.
entertain a continuance if it, say again?
I just
Carter,
feel
you've interrupted me when I'm talking, then I ask you what you said, then you won't respond.
Well, from the record of the year 23, I never touched anybody. There was no bodily harm, and look what I got, 30 months in prison.
I don't know anything.
I don't want to
about-
get this again.
All right, I'm going to put you down for the trial docket.
You know, if I may say something, this case was not assigned to me when it first started, and I noticed that the charges are incorrect in that count 1 is charged as felony battery level 1 for having a prior, but that's actually a battery on a over 65 years old, so that's gonna increase the points of the
The
score sheet.
level, but not the degree, right?
Not the degree, but the level,
Yeah,
yes,
sure.
Your Honor, correct.
So based on that, what would it change it to?
I'm looking for it, I don't remember if it's level 4 or 6. I'm just looking for it.
All right, but, so Mr. Carter, what they're saying is that 17 months I initially said is going to be higher because it's, the charging document has the wrong charge on it.
It's
So
level
they're
4, Your Honor.
Level 4 from a
Yes.
1, so what does that change it? I don't have a score sheet in front of me to do the math.
Okay, then I have to calculate 1 second.
And Mr. Carter, just understand, I'm not saying all these things to make it sound like it's some sort of threat as what's going to happen if you go to trial, but simply so you understand what the possibilities are if you do go to trial and if you're found guilty.
Yes, sir, I understand that. But, Your Honor, you have to understand me. I never laid my hands on no one.
Your Honor, for the
I
court-
understand that's what you've claimed now numerous times against the advice of your counsel and the admonition of this
I'm
court.
sorry, sir.
It's.
I'm country and I'm just defending myself.
So, just to be clear with what the court's doing, Your Honor, you are placing it on the trial docket.
I mean, I can't say for sure it's gonna go to trial because we've got other cases and I gotta deal with older cases first. And he's still gonna be within the speedy trial, but you have to tell a defendant who wants his trial that he can't get it when he's sitting in jail. I mean,
Excuse me for speaking, but, I mean, disorderly conduct, other things, other than, there's no battery. There's no
All right,
aggravated
Mr.
assault.
Carter, your case has been set for trial against my advice. Do you have anything else you want to
Well,
tell
I
the
don't
court?
know what else to
1
do.
second, let me.
No one's talked to me.
I have talked to you. I
Your
came to the
Honor-
jail and talked to you about it.
I calculated in your score sheet, it will score 31 months DOC minimum guidelines instead of 17.5 months guidelines. I would offer the guidelines as it is now, if he wants to plead. Another, I'm not sure if Mr. Mattox for sure doesn't know, because he probably just received discovery, but I want the court to know that the defendant's sister recorded the attack of the defendant. And it's very explicit about the abuse that she had to endure for about 20 minutes. that she recorded.
And the recording was made on the 1st, and I was not arrested till the 4th.
All right, take him back. Mr. Carter, you're just not listening to anybody at this point, so I'm going to keep you set for trial. I'll entertain a continuance at docket day on the 5th if need be. See what you can do to talk to him, Mr. Maddox.
Thank you, Your Honor. I appreciate the court's patience on that. Sorry, what was the name? Hey, Mr. Castile, how you doing?
I'm here.
Okay, Your Honor, Mr. Castile is before the court in 24 CF 2755 and 25 CF 748. That 25 CF 748 case is a brand-new charge. For that reason, Your Honor, I'm asking for a continuance. I also I believe I have some discovery I still need to request in the older case, Your Honor. So I believe I've emailed the state about that, but if I haven't, I certainly will by the end of today.
So I'm going to put this on the same pretrial conference as currently set. Well, I guess we're going to change it to June 24th at 9 o'clock. And then he's going to have his plea day on the new case, which is 25 CF 748, is May 29th.
Thank you, Your Honor. I'll come see you, Mr. Castile. Mr. Davis. Your Honor, I'm asking for this is Mr. Donald Davis, Your Honor, for the record before the court in 24 CF 1400, 25 CF 352, and 24 CF 2059. In the most recent case, 25 CF 352, Your Honor, we demanded discovery on February 27th. We are still waiting on that discovery unless it's been sent to me today or yesterday. But the state has been notified of that issue. I filed a second demand. It should be forthcoming, Your Honor.
Is there any way that go ahead and get
The
this up?
information wasn't filed until March 11th, but
Get it
we're
over with.
way past that. Mr. Sheik, I know you didn't have the case the whole time, but
Yes, Your Honor. So I think what happened is, in a lot of the cases, when it was an individual who wasn't represented at arraignment and then was added, some of those got mixed up. I'm going to make sure and take notes so this doesn't keep happening.
Okay.
But we're now tracking it. After Mr. Maddox told me, it just got lost in the cycle of changes. But I've resolved it so this type of stuff won't happen in the future, Your Honor.
okay, I appreciate
But
that.
we are tracking the discovery, and I already have the request in.
Mr. Sheik, does they have an offer to resolve it globally?
Right now, the current offer is 23 months DOC.
Mr. Davis has indicated he'd be willing to take an 1129 offer today despite the discovery concerns. Is the state amenable to that?
But it was a
Yeah. Would you be willing to set it to Monday? We can talk about between now and then? Yeah.
Sure.
We'll put you on Monday, May 5th, Mr. Davis, so they can continue to talk about that,
Thank you, sir.
and we'll see you on that date.
Okay. And, are you gonna come see me?
Yeah, I gotta go over that offer with you if it comes up, yeah.
You gonna come back
I will.
and see me?
No, I'll come back and see you. All right. Thank you, Mr. Chief. Mr. Noza. I'm asking, this is Mr. Nicholas Espinoza before the court in 24 CF 2353. Your Honor, I believe we have a bond motion scheduled for tomorrow, so I'll certainly have that heard. But I'm asking for a continuance at this time, Your Honor. I'm going to take some depositions in this case, I believe.
The state's aware of the bond motion that's set for tomorrow?
This was for Mr. Fillingham?
No, Espinoza.
Espinoza, okay, sorry, I had the wrong.
It looks like it was just filed yesterday. I just want to make sure everyone's on. I mean, I think the rule still says the notice requirement is 3 hours, which we obviously were outside of that, but I just wanted to make sure you guys knew that this is potentially set for a bond hearing for tomorrow.
Yes, we're aware of it.
Okay, just wanted to make sure. All right. All right, so we'll put it for purposes of pretrial 6/24 at 9 o'clock, but we got the bond motion tomorrow, so I'll entertain that at that point.
Thank you, Your Honor.
I think we're set for tomorrow at 12:30, so basically at our pretrial detention time.
This is the one we had the signed plea agreement in, Josh. Your Honor, we've reached a resolution in this case. May I approach?
Thank you, sir. All right, so this is a VOP where you're looking to modify the probation to add 6 months of community control.
Correct, Your Honor.
I mean, I think it's louder than y'all talking on the microphone. It's just,
I can out-talk, but I prefer not to.
I mean, I can hear every word back there. All right, Mr. Phelan, Jim, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Mr. Phelan, Jim, you're here in 24 CF 1211. This is a plea agreement to modify your probation. That calls for you to be modified to 6 months of community control with the remainder of your supervision to be regular probation. Complete all original terms. What would be the cost and fees on that? 100 and 100 for the PD, 100 and then. Okay. $100 VOP fee, $100 for the public defender fee. This calls for the maintaining of the withhold of adjudication. Is that the state's agreement?
It is, Your Honor.
Okay, it's a modification, but there are guidelines here that would show he didn't score. All right, Mr. Phelan, Jim, did you go over this plea agreement with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you I'm sorry, are you satisfied with your attorney's advice and representation?
Yes, Your Honor.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No, sir.
Has anyone forced, pressured, or threatened you in any way?
No, sir.
You understand that by entering a plea, there won't be a hearing of any kind to show that you violated your probation?
Yes, Your Honor.
And you understand you're waiving any potential defenses that you may have had to that violation of probation?
Yes, Your Honor.
All right, and what is your plea to the violation of probation? Are you admitting or denying that you violated your probation?
Admitting.
Admitting.
Okay, I'm going to accept your admission to the violation of probation. I'm going to modify your probation for the next 6 months to be on community control with the remainder of your original sentence to be regular probation, but understand the time that you've been in violation status, that time has tolled, which means it hasn't been running since that violation came out. Do you understand that?
Sir.
Okay. Complete all the original terms of your probation, 100 and 100 as far as your costs and fees, and then I'm going to maintain the withhold based on the agreement.
And Your Honor, I would just ask that the cost supervision continue to be waived.
It will be.
Okay.
Anything that I've missed, Mr. Berry? All right, thank you.
All right, man. Good luck.
Mr. Maddox already caught it, so.
Apologies, Your Honor.
Say again?
What was that?
Oh, yeah. Meet with probation, Mr. Phelan, Jim,
Okay.
and you have 30 days to appeal.
I have nothing further.
Not sure why you've been sticking around then.
See what was happening.
He enjoys the company, Your Honor.
It's funny, most days I don't see more than 1 or 2 people, except for these days I see like 300 people.
Your Honor, this is Miss Nikki Grimes before the court in 24 CF 1776. Your Honor, the state is going to, I believe, be looking at potentially giving me an amended offer. I'm not sure if they'll have that ready or not before the 5th.
I would be, well, I will know either way before the 5th.
Okay, so
Okay,
keep
can
it
we
on
put her on the
5th then?
5th then and see if she wants to plea to that? I would ask for a plea or continuance in that case, in this situation, Your Honor. I know it's an older case.
It's not terribly old, Mr. Maddox. I'm
Okay.
fine with that. And I know that's been the issue is y'all have had to talk to the alleged victim in the case, so. All right, we'll see you back on Monday, Ms. Grimes. That's May 5th.
On
We'll see
Monday?
if they-
No.
Monday.
I'll get you that offer. I'll see what it is.
All right, thank you.
You're welcome.
Yes, sir.
Yes, sir.
Your Honor, this is the first time up. This is Mr. Austin Geis before the court in 24 CF 2576 and 25 CF 375. It's first time up in the new case, Your Honor. For that reason, I am asking for a continuance and would ask to track both cases together to 6/24 pretrial date.
Your Honor, if I may, I would like to ask for the cases to be set for the VOP evidentiary hearing whenever the court is available.
Which case is the VOP?
Be in this case, Your Honor.
Uh,
It's two,
yes, there
it's
is a
two, I don't think so. I've got the battery by strangulation and the other charge is just standard possession of controlled substance and something else, I believe.
Yeah, a driving while license suspended.
I thought he was on probation, I mean.
I don't think so.
Was he on probation?
Your Honor, Mr. Geis was on community control with me previously, however, that was already revoked, I believe.
It was already resolved.
No.
I think so.
What do you mean it's been he pled to the VOP?
I thought he did.
Yeah, I don't, Your Honor, I'm definitely, certainly not tracking any sort of VOP
He had a
that's pending.
VOP that he pled out to in, looks like June of last year.
And then he caught this new charge after all that.
Yeah, I
It's
was
two-
never.
But, Your Honor, what
You got
I'm
it,
saying
yeah.
is, he was placed on community control last year, and when he got arrested for this case, he was on probation. He was on community control.
Yeah, again, I don't track that, Your
I
Honor.
don't think this was about like.
I don't track that at all.
Okay, hold on, we don't have to.
I remember, I wasn't
look at it.
present, but there was a
Of course.
bond hearing that was specially set. Let me see.
It looks like on June 6th of last year, he pled to the bench, which again is before my time, so I'm just reading what the notes say. He was given 6 months county jail and his CC was revoked and terminated at that time back in June of
Yes,
last
sir.
year.
That was my last dealing with Mr. Geis.
And I know we've seen Mr. Geis because we had, I think, do we have a pretrial detention hearing, then we had a bond hearing?
Correct.
So I just,
And what was forgive me, Your Honor, but where's the CC, what case number? Is that this case number or is
that's
that another?
23 CF 2535, I'm seeing that. Which again, would have been closed before I took over the division.
Okay.
This is almost a year ago. That seems to be the same thing from 23 CF 2533 as well. But then the new or the new cases are 24 CF 2576, which is from November of '24. So 5 months after he was terminated off of community control. And then obviously the new case, the 25 CF 375, is just from February.
That's fine, Your Honor, I apologize,
It's it's fine. I mean, there's plenty of times I make those mistakes about, is there a VOP, is there not, how many cases are there, just because of sometimes the way the docket prints out. So I think we've just got the two new cases. So I'm sorry again, what are you asking to do at this point, Mr. Maddox?
I'm just asking for a continuance, Your Honor.
No objection.
Okay. June 24th at 9 o'clock, Mr. Geis. See you back on that day.
Will do.
Judge, this is Donald Hanish. Case numbers for the record are 24 CF 1021 and 25 CF 146. I'm going to be taking over these cases, and I'll file a notice of appearance so we can clear it up with the clerk's website. Today, we're going to ask for a continuance on both cases for depositions. Based on the score sheet I saw in the 25 case, with both cases, he now scores currently 113 plus months in DOC. So we're going to ask for a continuance to June 24th.
Objections?
No objections, Your Honor.
All right, June 24th, Mr. Hanish, we'll see you back on that date. Mr. Russell's taking your case over.
Your Honor, this is Mr. Randall Hartley before the court in 24 CF 2882, 24 CF 48, and 23 CF 2692. Your Honor, the state did make an amended offer, which I did go over with Mr. Hartley. But in talking with him about his case, I do want to have an evaluation done for mitigation purposes, so I'm certainly going to request that report. And if need, I'll probably end up taking the law enforcement's deposition in this case as well, Your Honor, due to it being battery on law enforcement, although the state is willing to come down to a misdemeanor. But if we had a hearing, I do want to have that deposition just to see exactly what I'm up against.
State?
No objections, Your Honor.
All right, did y'all want to put the offer on the record or anything? I'm not telling you to, but if you want to.
The offer right now is currently 20 months DOC, and that's again amending the battery on a law enforcement officer to a misdemeanor battery.
Wait a minute. Oh, because of the VOPs too.
Correct.
All right.
Thank you, Your Honor.
24th, 9 o'clock.
Your Honor, this is Mr. Harvey Langley before the court in 24 CF 2897 and 24 CF 2715. Your Honor, at this time I am asking for a continuance in the case.
And what needs to be done?
So, Your Honor, I am still looking into a couple things. There's a couple of lingering
I'm not trying to get your strategy or anything like that.
No, I know. That's
These are
not.
5-month,
I understand.
almost 6-month-old cases.
I've discussed with the state, there are a couple of lingering discovery issues. I was going to see if I could, there was a surveillance video which was provided, but it was just body cam of that surveillance footage. So I was seeing if the state had an original copy or ever sought to get an original copy. There was also discussion of a receipt that I did not see that the officer mentioned in the report that was not provided to us that would show whether or not he made the purchase. So those are the two things that I was seeking to see if the state had, Your Honor. So that's where I'm at. And then in regards to, well, that's it. Those are the lingering discovery issues, Your Honor, and those should be relatively easy to figure out.
State, no objections?
No objection, and yeah, the current offer from the state is we would be willing to dismiss 24 CF 2715 for a plea to 24 CF 2897 for 1129 OCJ.
Okay.
I'll address that in a second. And then if Your Honor, if I may, I did have an uncontested bond motion that I spoke to the state about. The state had no objection. I did go ahead and file it. Obviously, there was no notice of hearing filed, so if that needs to be done, we can reschedule it, but it was just very, very brief, Your Honor, and the state had no objection to reinstating Mr. Langley's bond. And that was in 24 CF 2715 where the bond had been revoked, Your Honor.
So he has a bond on the other case?
Yes, Your Honor.
I can see the motion. I just had to look up the motion a different way because it was just filed. It's not in my system yet. The state doesn't have an objection to reinstating this bond.
That is correct, Your Honor. We don't stipulate to it, but we
We're not
won't hold any
objecting to it.
objection.
Mr. Langley, do you know who your caseworker is?
From a DCF case? Yes, sir. Ms. Nunu?
So you're ready to hit the ground running on that?
I brought some, I was gonna bring you some certificates I've been going for the high school, but knowing me, I forgot them. But yeah, I'm all over it. Yes, sir.
And not to interject about something I know not too much about, Your Honor, but Mr. Langley has voiced his readiness to.
He's talked about it before.
Yeah, okay.
And I think it's in your motion, so that's why I bring it up. So there's no objection, but what exactly are you asking for in the bond motion? You just reinstate to what it was before?
Yes, Your Honor.
Which was what?
I believe it was $1,000 cash professional. That's right? $1,000 cash professional?
Yes, sir.
Yeah.
That's what it was.
Okay.
Looks like right, all right.
You're correct, Your Honor. I don't know why I didn't include that in the motion. My apologies.
All right, so based on no objection, I've reviewed the file. Obviously, these are petty thefts, but they're felonies. Mr. Langley?
I wish I
I'm
could.
not, obviously, you know, the cases are pending, but, you know, we got to make sure that we not put ourselves in this kind of situation. You got a lot of work to do in your other case. I'd rather you be doing that, and I'm going to go ahead and reinstate your $1,000 cash and professional bond. Will the court minutes be sufficient for that?
The court needs an order, Your Honor. I'd be happy to provide
Send me
it.
over an order just to make sure, otherwise, you know, he'll be waiting around, and I'm not saying it's going to get done today, Mr. Langley, so just be prepared. It may not get signed till tomorrow. I'm ordering it now, but they may need that order, a physical order to be signed. You know, Mr. Maddox is here, I'm here, so we may not get to it today, but we'll do our best. Just make sure when you send that over, send it kind of priority to my assistant, and we'll get it done.
Yes, Your Honor. Word document?
Yes, just to make it easy. Every once in a while, there's just a minor typo I need to fix, so I'd like it to be fixable.
So don't call Bulldog yet. Don't call him just
You
yet.
can get them ready.
Yeah, you can get them.
I already had my standby.
Make sure you call and get an appointment set up here soon, as soon as you can. Okay.
But I would say also, as the former judge on the other part of the division, all I'm saying is hit it right away. June 24th. I understand, but I'm saying you've got things to do. Make sure you get right on them.
Good word for me.
Can't do that.
Your Honor, this is Mr. Jeffrey Moore before the court in 24 CF 2894, 24 CF 1357, and 24 CF 1358, Your Honor. The newest charge is related to animal cruelty. The state's informed me that the current offer is revoked. That's not to say that there won't be an offer in the near future, but it has been revoked, so that obviously changes things from our perspective quite drastically. Also, Your Honor, there's been no depositions scheduled in this case. I know it's getting to be old, so I will certainly schedule depositions in this case. So I'd ask for continuance.
All right, State.
No objection, Your Honor.
All right, Mr. Moore, you're going to see you back on June 24th at 9 o'clock.
Judge, this should be Jonathan Murphy. Case number is 24 CF 2181. I'll be taking this case over from Mr. Maddox and filing notice of appearance to make the record clear. Score sheet indicates he scores 21.68 months, Department of Corrections. We just got an evaluation back from Dr. Zeman Monday that I haven't had a chance to go over with Mr. Murphy, but we may be able to come up with some alternative resolution other than DOC, and if not, then I'll have to take depo. So at this time, I am asking for a continuance.
The state has no objection. The new offer from the state on this one would be 1129 OCJ with ECLC, a condition of the jail time.
Yeah. Judge, can we put this on the May 5th docket day, Monday? Plea or continue?
All right, Mr. Murphy, we'll see you back on Monday, the 5th, and it sounds like there might be some resolution. All right,
Okay.
we'll see you then.
Mr. Russell, before you leave, can I say something? So you may need to.
Murphy?
Oh, I'm sorry.
All ready? Okay.
Yeah, I'm ready to go. I just want to make sure I didn't cut you off
I
there.
thought they were waiting to see if Mr. Murphy was coming back.
Oh, that's
I
fine
didn't see
too.
you
Yeah,
on
I don't.
there. Go ahead.
Okay. Your Honor, this is Miss Gloria Pettit before the court. Did I say that right, Pettit?
Yes.
Okay. Before the court in 25 CF 343, 23 CF 1829, and 24 CF 738. Your Honor, it is her first time up, but we had passed her to docket day. We did get some stuff from Savings Grace indicating that she got into there, and the state is reviewing that for possible potential resolution in the case.
Okay, so you want to keep it on for the 5th?
Yes, Your Honor. Plea or continue.
All right. Ms. Pettit, we'll see you back on Monday, the 5th. Sounds like the state's looking over the things that you've provided, and maybe we'll resolve the case that day.
I can talk to you about that.
All right. Thank you.
It's ready. Your Honor, this is Mr. Marcus Redding before the court in 25 CF 390 and 24 CF 2214. Your Honor, I am asking for a continuance, and I'd like to run both cases together. 25 CF 390, it's the case's first time up, Your Honor.
No objections, Your Honor.
June 24th, Mr. Redding, we'll see you back on that date.
Your Honor, this is Mr. Dan Reeves before the court in 25 CF 152. Your Honor, this is another case where the state was notified about discovery. It will certainly be forthcoming. We've had that conversation. It is the case's first time up, Your Honor. I'd ask for a continuance.
All right, June 24th at 9 o'clock for Mr. Reeves.
Schofield. Hey, I'm doing all right. Okay. Your Honor, this is Mr. Robert Schofield before the court in 4 cases, 24 CF 1844, 24 CF 2080, 25 CF 495, and 25 CF 398. Your Honor, we've discussed this case extensively, had some disagreements among ourselves. It's Mr. Schofield's intention to represent himself. At least that's what he conveyed to me as of yesterday.
Your Honor, that's not entirely true. I just wanted to present these motions, and I asked him to adopt them, and he just said that he wouldn't do it. So
that's correct.
So he said, well, if you present the motions, you're going to be representing yourself. I said, I don't think I'm qualified really to represent myself like you are.
Let me explain this. I explained this to someone else earlier, Mr. Schofield. When you file things, which like you have, I think you filed a notice of expiration, a speedy trial, specifically in a case where you failed to appear at your plea day, so that kind of prevents, you've waived speedy trial by not showing up for court. So when you tell your lawyer, or you ask your lawyer to file a motion and he says, I can't do that, it's usually because he has an ethical obligation to only file things that are legally sufficient. And so I haven't seen the motions, I don't know what you're talking about, but this is often the way it happens.
These are very diligently written, sir, and if you would just take them, you're the one that reinstated my bond when I came to court. You're the one that reinstated my bond because you said he failed to appear twice, and they said, no, Your Honor, we have no problem reinstating Mr. Schofield's bond. And they let me go because they told me the wrong court date. And you're the one said, wait a minute, he failed to appear twice. And they said, no, Your Honor, we will reinstate both bonds. And you're the one that let me go.
When was that?
It was on January, I had Lisa Rivers standing here beside me. I believe it was January the 30th.
Okay, and then you have allegedly got 2 new cases since then.
Yes, sir, I did, but I didn't fail to appear. I was informed the wrong court date. I called Judge Quinteric, his office, and tried to appear by Zoom. And then by then I had already been a failure to appear. But so when I came to court, Ms. Rivers was like, look, I'm going to get the recording to see. And when I went back and put Amy Clark, she said, make sure you got 2 separate court dates, Mr. Schofield. Make sure you appear at them. And I said, yes, ma'am.
All right, so you want a speedy trial?
Yes.
You're set for trial.
Thank you. Could I present these documents to the court?
Your Honor, I've got some things I would like to address with the court. And it's first of all, he was trying to file an expiration speedy trial, but if he wants to set the cases for trial, that's fine. Again, yesterday he told me he wanted to represent himself. Certainly, if he doesn't want to do that now, that's perfectly fine. I'm happy to proceed to trial. But Your Honor, my advice to Mr. Schofield was that I wanted to take depositions in both of his cases based on some of the things that he's told me, and also to be more ready for trial than I otherwise would be with just the discovery that I have. And it would be against my advice at this point for him to proceed to trial. If he still wants to, that's fine. I can be prepared to go to trial with what I have in both of the cases, Your Honor. That's not my concern. My concern is I want to make sure he's making an educated decision about that, and if he wants to address anything else with the court, he's certainly welcome
Please,
to.
Mr. Maddox, we looked at those videos yesterday, and
Don't discuss the facts of the case.
Just everyone else is listening to you if you discuss it out here.
It's okay. I'm not gonna. I know that that's not me in that video, and I know.
Don't discuss the facts of the case.
I mean, I've had the same conversation at least twice already with other people today. Everything you say in here is going to get recorded. Okay?
Yes, sir, but that incident is a totally separate incident than what I thought that I was allegedly involved in. That's why when I seen the video yesterday, I was like, wow. I was like, yeah, we need to show this to
Mr. Schofield, I'm not going to say it again. Stop talking about the facts of your case.
Yes, sir.
I'm not trying to be difficult towards you. I'm trying to protect your rights.
And I'm certainly not trying to be difficult towards you,
You have a right to remain silent, okay? Everything that you say in this room is recorded and will be used against you by the state attorneys who are sitting here listening to you, and you're potentially not even just giving away things that are detrimental, you're giving away your trial strategies in open court.
I want to go home.
Well, I understand that, sir, but you've got 4 pending cases.
And if I may, Your Honor, the offer conveyed by the state, which Mr. Schofield has expressly rejected, is 1129 in the Okaloosa County Jail, credit for all time served. The state would dismiss 24 CF 1844 in exchange for the plea of the other three cases.
This is the one at Walmart. I was in here going to jail. That gentleman right there took me into custody on the same date they're saying I stole 2 bottles of liquor out of Walmart.
Don't talk about the facts of the case. Mr. Schofield, please.
All right, which case are we going to try first? One of the 224 cases.
I don't really have a preference for either one, Your Honor. Either one's fine.
Mr. Sheik.
I suppose if I had to pick, Your Honor, I would go with 24 CF 2080.
Second, and state's okay with that case going first, Your Honor.
Okay, so go to trial. I don't know the difference between any of them. That's why I asked the lawyers to decide that. So 24 CF 2080 will be set for trial. The other cases will run along with it. Are you okay with that?
Yes, sir,
Mr.
Your Honor.
Schofield?
I'd ask for a continuance in the other two cases, Your Honor, the two new cases before the court in 25 CF 495 and 25 CF 398.
Please no, Your Honor. I don't want any continuance.
Those are both.
Take a breath, Mr. Schofield. We're going to talk about these cases. One is going to be set for trial. The other ones are going to run along with it. We can't try 4 cases in one trial period. Okay? It's just not how it works, especially those other cases. The new cases are... one of them is not even 2 months old yet.
Yes, sir. I did file a demand in case number CF 00495C. I got the memorandum right here from the clerk of court. There's also been some confusion with the clerk of court. I've written
Hold on
them
a
in.
second. Which one are you talking? 495? That's the latest one. That case
I
is
don't
not
even know if I have
2 months
discovery in
old
that
yet.
case, Your Honor.
Say
It
again.
was filed on March the 18th, 2025.
Okay. I want to make sure you understand something, Mr. Schofield. When you demand speedy trial, that means I'm ready for trial. I'm not going to engage in more discovery. I don't need to talk to any witnesses. All my witnesses are lined up, and I'm ready to go.
I am, because I was in here going to jail. He took me into custody.
Okay, I'm not sure why you keep pointing at the person who took you into custody. What does that matter?
Because I was here on that date and time.
Thank you.
I was in this courtroom getting apprehended.
Then has there been an alibi notice done?
My girlfriend will be here to.
That's not my question.
No, Your Honor, well, honestly, I don't want to get into that. He's made me aware of that situation. I'm looking into it. That's what I'll say to the court on that matter, Your Honor. It's dealing with the allegations and dates in an arrest report.
Okay. But I can't set you for 4 trials in one trial period.
Yes, sir.
So I'd like to get your older cases resolved. This one, even if I continued it, I could probably continue it twice and you'd still be within speedy trial. I'm not saying I'm going to do that. I'm just saying, it's brand new. And you got to give your lawyer a chance to work on it. As you said, you don't think you're really able to handle this kind of stuff on your own, so let the professional take it.
But you know what, Your Honor, I know that they don't have any evidence, and I know I was in here, so I will, if I have to go pro se, then I will, because I don't want any continuances in none of my cases, with all due respect.
Okay,
To
well,
you as the head officer of this court, please.
I'm telling you, we're going to try one of your cases this time around. We've picked which one that is. But I can't set you for 4 jury trials in a week.
Yes, sir, I understand.
So 1844 is going to be continued, Your Honor, or I just want to be
Let's
clear.
just keep them all on for docket day Monday, see how
Figure it out.
things kind of evolve, and then we'll deal with it.
Where does the state stand in regards to the offer made? Does it stay open till the docket day, or where are we at?
State will keep the offer open until May 5th.
Thank you.
Thank you for being fair with me.
Okay, Mr. Schofield, you just have to understand that there's a process to this. As much as you want it to go fast, we're not built to just have trials within, weeks, a couple of weeks of a case being opened.
Yes, sir.
It just doesn't work that fast.
All right, thank you, Mr.
All right,
Manager.
thank you.
Thank you, Mr. Schofield.
Thank you.
Your Honor, this is Mr. Michael Strauss before the court in 24 CF 50, 24 CF 578, excuse me, and 25 CF 257. Your Honor, 25 CF 257, it's a first time up in that case. I'd ask the cases be tracked together, and I would be asking for a continuance, Your Honor.
No objection.
All right, hearing no objections, June 24th.
Thank you.
Cordell Thomas, we already did. We already covered your Cordell Thomas case, right?
Yes, Your Honor. Hey, Ms. Thompson, how you doing?
Good, how you doing?
Good.
Mr. Maddox?
Your Honor, this is Ms. Janiah Thompson in 23 CF 311. Your Honor, this is another case where I was waiting for discovery in. I've gotten with the state on that. They have it forthcoming, so that will be addressed, Your Honor. I do also have an uncontested motion, so I'd ask for a continuance on that basis, Your Honor, to the pretrial docket to June 24th.
Any objections?
No objections, Your Honor.
All right, June 24th.
And if I may, Your Honor, I also had an uncontested bond motion in this case that the state and I discussed was filed.
What was the basis for it?
Your Honor, so she has, among other things, she has no criminal history. There are some concerns that I've shared with the state with respect to what exactly happened in this case, Your Honor, but she has no criminal history. Her failure to appear dated back in 2023. She's ready to confront the case head-on. Again, the state has no objection. She has a 4-month-old daughter to care for, Your Honor, and she would live locally. She's trying to regain her employment at Burger King as a manager, which she may still have available, and she would reside locally at 3 Cherokee Trail, Pensacola, Florida, 32506, Your Honor. She's lived locally there for 10-plus years.
Your Honor, may we approach?
Yes.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, Ms. Thompson, we had a brief discussion at the bench just about the kind of the background of your case. When I heard an unopposed motion to reinstate bond on a case where there's been a failure to appear, my immediate response was, why would I do that? But after them explaining some things to me as far as concerns about the actual case, they've changed my mind. So based on the unopposed motion to reinstate bond, I'm going to reinstate that to the $2,000 cash or professional bond that was originally given to you. And what do you want to do? We've already moved the case to June 24. Well, if you are you going to be able to make that bond? Okay, let's put it on June 23rd then. That's the
yes.
The non-incarcerated docket. Okay. So we'll put you on June 23rd. We'll change that at 1 o'clock. Thank you.
All right.
We'll see you back on that.
Stay in
Make sure you
touch with
stay in
me,
touch
okay?
with your lawyer.
Did I give you my card? You have one? Okay, let me grab you one. Call me and give me your contact information.
And Mr. Maddox, just make sure to follow up if they need an order to get her out on that.
Of course, Your Honor.
I should be in the office all day tomorrow working on stuff other than when we're here for a short period of time, so I'll be able to sign it.
Okay, perfect. And I think I'll be here for that one other bond motion, so certainly if I hadn't gotten to you for some reason, I'll have them in
Bring it
hand.
to me and I'll
Yes,
sign
Your
it
Honor.
on the spot.
All right. Your Honor, this is Miss Angela Watson before the court in 25 CF 19. Your Honor, we recently did receive a competency report back making recommendations. I don't believe the state has any objection stipulating to it. Does the state have the report?
Yes, the state has the report, and we have no objections to it.
Okay, may I approach with the report then, Your Honor?
Oh, yes, I haven't seen it.
Pre-trial conference, ma'am, but like we talked.
Based on my review of the file and the evaluation that's been provided and the stipulation to that report, I am going to find that she's not competent to proceed. As far as the next step, it would be for Florida State Hospital, or no?
That appears to be the recommendation, Your Honor.
All right, then send me over an order on that, Mr. Maddox.
Will do. Your Honor, this is Mr. Robert Watson, 25 CF 274. Your Honor, this is his first time up. I'm asking for a continuance.
Robert Watson.
Yes, Your Honor.
All right, June 24th, 9 o'clock. Thank you, Mr. Watson.
Okay, perfect, thank you. Your Honor, this is Mr. Tyler Webb before the court in 25 CF 253. Your Honor, it is the first time up. I'm asking for a continuance in this case.
No objection.
June 24th, 9 o'clock.
to June 24th so I can take depositions.
No objections, but the state has an amended offer.
What's that?
Lead to both of them, but in 24 CF 2907, we would dismiss counts 2 through 9, which would make him not score, and it'd be 1129 OCJ with ECLC.
Maybe leave that on for Monday.
That sounds good, Judge. Can he complete the ECLC with his current credit?
Well, just abide by.
Okay, comply, or whatever the word is. Okay.
As I was corrected earlier, it's comply, not complete.
That'll work, Judge. We'll set it for Monday.
All right, we'll see you on Monday, Mr. Bell.
Judge, this is Dwayne Bonnik. Case number is 24 CF 2696. If I could just have a moment. So, Judge, at this time, we're going to ask Mr. Bonnik's case be passed to docket day. Plea will continue on Monday for a possible resolution. The state and I talked this morning, and he's got to clear some stuff with the victims.
All right, we'll see you on Monday, is it Bonnik? Am I saying that right?
Oh, yes, sir.
All right, we'll
Thank
see
you,
you on
Judge.
Monday for a plea continuance.
All right, thank you, Judge.
You're welcome.
Judge, this should be Kelvin Brown. Case number is 22 CF 1823, 24 CF 2757, and then another 22 case CF 1420. The 22 cases are violations of probation. The 24 CF case is a new law violation. Mr. Brown filed a request for Nelson hearing, which we've set to be heard by the court on May 29th at 2 o'clock.
Just so I understand, is that just against the PD's office in general, or?
I believe the allegations are against me, Judge, based on some stuff that we talked about.
Okay. I just want to know what to prepare for.
Yes, sir.
I hadn't seen the actual motion, so let's see, or notice. Sorry, the motion for the Nelson hearing didn't appear in all the cases, so.
Oh, I'm sorry, Judge.
No, it's fine. I just wanted to make sure I saw it. And usually I try to look at these things in advance, but I don't always open every single person's case, everyone's multiple cases.
Yes, sir. I did file the notice for hearing for all cases because I think the VOP is based in part on the new law.
That's fine. I think he'd only sent it in and it was only put into 2757, which is the new case.
Correct.
I think it's just because one of the VOPs has his middle name spelled differently, so it's going last even though it should be higher up. And so I usually look at the last case to kind of see what's going on, and I just didn't see the Nelson request. So we'll hear that on May 29th, Mr. Brown. We'll see you back on that date, and then depending on obviously what happens in the meantime or on that date, we'll decide what's going to happen with your case next. All right, thank you, sir.
Judges Zakeem Callaway, case number is 23 CF 923. At this time, what we're requesting, judges, Mr. Gibbs had taken 2 out of the 3 officers. He said all 3, but one of them did not show. That officer was not reset. I've reset him for this Friday, so we'd like to leave it for plea or trial on Monday the 5th.
The trial on Monday?
Yes, sir.
All right, so Mr. Callaway, we'll see you back to Monday the 5th. I'm going to put you down for a plea or trial.
Judges, this is Wanda Carpenter. Her case numbers are 24 CF 909 and 24 CF 1124. A couple things going on in this case. We have a comp evaluation pending, but we also have depots set for Friday, May the 2nd. The returns that we've gotten so far, one of the alleged victims is deceased, and the other one is not served at the address provided by the state. If you want to set it for plea or continue, well, it really can't be a plea. If you want to set it for call on Monday the 5th, we can see if the state has a chance to look at it between now and then, and they can make a decision about whether or not they're going to even pursue them, because,
They have to have a victim.
Correct.
Okay. I'm not sure what you've got there, Ms. Carpenter, but you can show it to your lawyer. We'll come back on May 5th for docket day.
Okay, hold on to that, because I'll...
Status. All right, we'll see you back on Monday, Ms. Carpenter.
Yes, sir.
Judge, this is Joseph Carroll. Case number is 24 CF 2383. If I could just have a second. On Mr. Carroll's case, Judge, we're asking to continue his case until the June 24th docket for depositions.
No objection.
Are those already set, or?
No, sir, they'll have to be set.
You said. All right, Mr. Carroll, we'll see you back on June 24th.
And before we start Mr. Williams' cases, Judge, I have a defendant who was scheduled for court Monday. He didn't show up. He's here today. For the clerk's information, defendant's name is Larry Mayo, M-A-Y-O. Case number is 24 CF 2367. When he didn't show up Monday, the court had issued a capias, no bond. A couple things. We're asking that the court withdraw that capias, and then we'd like to set his case for Monday the 5th at 9 for plea or continuance. There's an offer that I need to discuss with Mr. Mayo that may resolve the case on Monday.
What happened Monday?
I got confused. I thought it was the 30th. Watching court TV and seen I heard my name called. So I get up there.
You're helping people out, Ken. I kind of feel like that guy that we had that came running in the last minute on Monday probably saw his or heard his name on TV. Were you in jail recently or no?
No, sir.
I'm just, because the Wednesday date is usually for the incarcerated people, and frankly, who knows? I may have told you the 30th and just gave you the wrong date. So,
Yes, sir.
But you're here,
You won't have me
so
here.
I'll withdraw the capias.
Thank you.
For Mr. Mayo, and we'll see you back on Monday, May 5th. So this coming Monday at 9 o'clock.
Okay.
Make sure you're here.
Yes, sir, I will.
I'm not sure if we'll have a TV camera here.
Thank you.
Help you get here. So we'll see you on that date. You doing all that, but you don't need time to figure that out. Cool.
I'm sorry, I did not hear the name. Allen? Okay. Judge, this is going to be actually your James Woodard Allen, correct?
Yes, sir.
Okay.
sir. All right, so Mr. Allen has 1, 2, 3, 4, 5 cases. I've been handed a plea and sentencing agreement calls for him to plead to 3 of those as charged, and the other 2 are being dismissed. Is that right?
That's correct, yeah.
Okay. All right, Mr. Allen, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. There's a lot of this, so I'm going to go through it and make sure you understand what you're here for. So you're here in 24 CF 375 on charges of possession of a controlled substance, third-degree felony, fleeing or attempting to elude, which is a third-degree felony, no vehicle registration, 60 days county jail, maximum as a second-degree misdemeanor. I got count 4 as driving license suspended, HTO is 60 days jail maximum. Is it a
Judge, that's how they wrote it up. I don't know if they meant 60 days or if they meant HTO, but it's a DWLS, and the information in that case showed it as being an M2.
Okay. Well, can you still get an HTO if it's financial only, it's still a misdemeanor?
Yeah, there's 2 different kinds, and one of them is just a misdemeanor, and then the other one's a felony.
It's just been so long since I've done traffic. Sometimes those nuances are lost. That's why I ask the questions. Also, we're resisting without violence, which is a first-degree misdemeanor. Then in 24 CF 374, it's a fleeing to elude, third-degree felony, violation of pretrial release, which is a first-degree misdemeanor. You've got 24 CF 1668, dealing in stolen property, second-degree felony. And then 2 cases which are going to be, looks like, dismissed as part of your plea agreement, Mr. Allen, is 23 CF 2644, which is a DV by strangulation, third-degree felony, and 24 CF 373, which is a burglary with battery, which is a life felony, 2 aggravated assault, third-degree felonies, and a battery, first-degree misdemeanor. Those would be dismissed as part of this plea, with you doing 44 months in the Department of Corrections. Is that your understanding, Mr. Allen?
Yes, sir.
And is that what you want to do here today? All right, so have you gone over this plea and sentencing agreement?
Yes, sir.
Did you understand it? All right, and did you did you sign it? I'm sorry.
Sir.
And are you satisfied with your attorney's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Just wait for me to finish so it's clear. Are you currently suffering from any mental health issues or concerns?
No, sir.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea? Do you understand by entering a plea, there won't be a trial of any kind in any of these charges, and you're waiving any potential, you're waiving all of your trial rights, which are on page 2 of your agreement? And you understand you're waiving any potential defenses that you may have?
Yes, sir.
Do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. Do you have any questions for me about it?
No, sir.
Okay. All right, so what is your plea as to 24 CF 375, 24 CF 374, and 24 CF 1668?
Contest, sir.
All right, I'll accept your no contest plea as to those cases. It's going to be adjudication of guilt on all counts, 44 months Department of Corrections to be run concurrent between those cases, credit for all time served. Court costs are going to be $615 on the drug case, which is 24 CF 375, $515 on each of the others, $115 or $150 in PD fees. What I'll do is I'll give you 90 days from the. Oh, do you want time to pay those after you get out, or just want to go straight to collection?
I got to pay on collections anyway. I've been paying on it.
So court costs will be the judgment. All right, and then on the other cases, 23 CF 2644 and 24 CF 373, does the state have an announcement?
Yeah, the state dismisses those 2 cases.
Okay. All right, so Mr. Allen, again, it's 44 months. Let me just see here. Because of the possession of the controlled substance, there's going to be a driver's license suspension that comes through for the DMV.
Paying on for now is all that.
Okay, well, just anytime you get a drug charge like that one is, there's a suspension that comes up from DMV. You can potentially get a work permit or a business purpose license. You're just gonna have to deal with the DMV once you get out, because the suspension doesn't start until you get out.
How long is the suspension?
It's 1 year now. It used to be 2, but it's 1 year.
Okay, it's 1 year. Obviously, if you're otherwise eligible, I wouldn't have any issue with you getting a driving permit, but you have to make sure everything else is cleaned up first. All right, other than that, I just need your fingerprints. Well, let me make sure I fix this. On all the felony counts, it's going to be the 44 months DOC concurrent. On the driving while license suspended and no vehicle registration, the violation of the PTR, those will be time served.
Yes, sir.
Okay. And in each of the felony cases will be the 44 months. You need to be fingerprinted, Mr. Allen, and you have 30 days to appeal the judgment and sentence of the court. I've reviewed the guidelines. They came out to 43.5, so this is a guideline sentence.
Yes, sir.
All right, thank you.
Senator, how many cases going to be concurrent with this?
You're going to have to deal with Santa Rosa on that, okay? You can't run something concurrent to a sentence that hadn't been imposed yet. Judge, this is Christopher Arnett. Judge, we're disputing some issues on the guidelines. The state's going to have some fingerprints compared to a JNS on a case that they're alleging intervenes that keeps a prior record alive. Otherwise, the prior record would be too stale for the guidelines. So I don't know if that's something that's going to be possibly done by Monday, or if we need to just continue this out.
Is it a local case?
No, Judge, it's, I'm trying to remember the Holmes County. It's a misdemeanor, but it's a petty theft, so there should be fingerprints on the JNS.
I guess, Your Honor, what I want to say is that the issue, so he has a pending felony case out of Holmes County. So that means to have that case, he was arrested for a crime. And that was within the 10 years from the date of the primary offense that is set here in front of this court. So based on that, all the prior criminal records comes in. And now they're saying, I guess, that that's not his fingerprints, that he does not have a case in Holmes County. If he doesn't have it, I'd like to know, because, and that's Florida criminal history. Mr. Williams has access to that.
He's not been determined to be guilty on that. Just because you get arrested doesn't keep your record alive. You have to be arrested and ultimately sentenced on it. So what you provided was a misdemeanor petty theft case out of Holmes County that's, I want to say from like maybe 21 or so. Let me see here. And that would not be unless that's his case. Yeah, you provided me with 2022 MM 3582. And actually, no, that was an Okaloosa case, petty theft to hunters, so that would be local.
What about Holmes County 21 CF 19, which is a criminal mischief felony for which he was adjudicated guilty?
That's the only.
So I don't think we got a dispute, right?
And is that the case that's pending in Holmes County?
No, I've sentenced on that already.
So again, he was sentenced on the Holmes County case.
Not just. Judge, let's leave it on for Monday. I'll talk with him again. But my understanding is that he had gone in excess of 10 years from the manslaughter case before the next arrest. And the one that she gave me was this 2022 petty theft. And in speaking with him, he says that that's not him.
Manslaughter case was here?
No, it was not.
No, it's in Okaloosa. She's also got it charged or got it scored twice. There's actually only one.
What county was it in?
Hang on, Judge, I can give it to you.
The manslaughter is out of state, right?
Right, it's,
Yeah.
did
Yeah.
I say Okaloosa? I meant Oklahoma, sorry.
Yeah, no, that's fine.
Here's the,
It's fine, I was just wondering if it could be looked up, and so.
here's the paperwork on it, Judge.
I don't need it, I was just asking if it was local.
No, the manslaughter's from Oklahoma.
And so what, it's 10 years from his release from all incarceration and supervision?
Yes, sir, that's what we're.
I'll let you tell and take a look at it.
The issue is.
Okay. All right, then y'all want to come back Monday?
If she can get it done by then, if not, I guess I'll have to take the hit on continuing it.
I mean, y'all have CCIS, right?
We do.
Yes, Your Honor.
I mean,
But it's a matter of
I can
is
see the
this-
21
yeah.
case, it's just, so
Well,
that
you
way
know,
you
Your
can.
Honor, I don't see the 21 case. Oh, it's not out of Okaloosa County?
Holmes County.
Holmes County, I'm sorry. Okay. No, I'm not looking at
And
that.
that's the only county I looked, because that's the one y'all said it was in, so. But
Yes.
it seems to be the same date of birth. And
That's
I'm no
how I
fingerprint
searched
expert. There are
it.
fingerprints in that file, but I can't see, you know, I'm not an expert on it.
Right. We're not competent to make that decision, Judge. So in any event, that's
All right, so
the defense's position.
all right, let's come back on Monday, see if y'all can figure that out by looking at it. Obviously, I'm not expecting fingerprint analysis and comparisons by Monday, but if y'all can figure it out, great.
All right, so we'll have it Monday for call.
Yes.
All righty. All right, so once we find out something, I'll be out to see you again. Otherwise, I'll see you on Monday.
Do we have that?
Oh, she's rejected the counteroffer.
What was that? Just kind of hit me in the past 2 minutes.
So apparently, I'm going to need to find a notice of alibi as well, Judge. I think, well, he's already left, so let's bring it in on Monday, and if I need to continue, I'll continue it then. Sorry, Judge. Mr. Booker? Okay. Judge, I'm going to move to continue this case. I also have received a note that a witness that we've just gotten information on, maybe a witness in another case of mine, so we may wind up having to do a conflict thing.
What's going on with the older case, though?
I've got 24, 305, and 354.
Actually, they're both from over a year ago.
Right, both from 24. These are cruelty to a child cases. I've got them as Ms. Barrickman's.
They are, I believe.
Are they new to you, Mr. Williams?
They are, Judge. Ms. Barrickman either is sending or has sent over her correspondence with Tim regarding any offers and score sheets. I saw him at the jail and went over the case and the offer and advised him that I would continue the case and take depots. I've got a note here that says, believe that my legal assistant already has this, where I've set it. And next time around, it should either be a trial or a plea. We do have some, I've got a follow-up note on that. Depositions have been set for 6/16 from 9 to 11.
All right, Mr. Booker, then we'll see you back on June 24th. Obviously, it looks like a lot of work's going to be done between now and then we'll see where you're at that point. All right,
Thank you,
sir.
Judge. Judge, this is Roger Bradshaw. We did take the alleged victim's deposition. I've gone out to the jail and discussed that with my client. Based on that, there's an adult daughter that wound up being involved in one of these conversations about bringing the car back. So I'm going to schedule her deposition. Let's see. I've also got my investigator checking in some questions on his prior record. So I'm going to move to continue to take that deposition.
No objection.
All right. June 24th, Mr. Bradshaw, we'll see you back on that.
Thank you, Judge. Okay. Judge, this is another one that's new to me. We've gotten the lab reports back. I met with him at the jail and gone over that and gone over the offer with him. Looks like I need to potentially set depositions. I've definitely got to check the times in terms of the length of detention, the CAD reports, and then the body cams. At this point, I'm going to go ahead and set the depositions. If I get a firm answer on everything from the body cams, I'll cancel them.
Case is getting a little bit on the older side as well. I know it's new to you, Mr. Williams, but
yes, sir.
Let's see if we can make it a priority. June 24th, we'll see you back on that date, Mr. Braley.
Yes, sir.
Okay. Judge, this is Chad Brown. We've made a counteroffer to the state. The state's indicated they're going to speak with the victim about it. If we can pass him till Monday without subpoenas, we may be able to get it resolved on Monday.
Yes, Your Honor, I just need the time to discuss the counteroffer with the victim.
Thank you, Judge.
June
All right.
24th. Oh, I'm sorry, you wanted that for Monday, right?
Yes, sir.
May 5th.
All right, so they're looking at the counteroffer that we made, all right, and they're going to talk with the alleged victim about it, and we'll find out Monday if they'll take it.
Okay.
Okay.
The reason I kind of paused is for some reason your name is ringing familiar, so I'm not sure if I've handled the case of yours or just, I always try to find out if there's any reason why I maybe had been involved in a case a long time ago or something like that. So if you think of something by Monday, or if I do, I'll certainly bring it up, but I don't know why your name is just, especially even your middle name is just for some reason ringing a bell to me. Could just be someone with the same name from another county I handled or something. No worries.
All right. Judge, this is a case where I think we've got it worked out. What my notes are is to pass it until Monday for a probable plea. I think there's some question back and forth, and it's kind of a weird situation.
Mr. Cooper?
This is Randy Cooper, yes, sir. The state's made an offer to him that he's amenable to, but he was wanting me to add a year probation with a drug program on it, just for his personal betterment, and I've explained to him the possible ways that could go bad for him. Ms. Claw's now gotten involved, and there may be another alternative that we can present to him by Monday, and so my notes are just pass it for Monday with negotiations open and see what we come up with to resolve it.
Yes, no, Your Honor, I'm considering the counteroffer and this new offer, but I need to discuss it with victims.
Okay.
All right.
All right, May 5th for plea or continue.
Thank you, Judge.
9 o'clock.
Judge, this is Aaron Copeland. Sorry, Judge, the file got shuffled. Judge, this is going to be a negotiated plea, but it's kind of weird. All right, so the state looked into the new law violation, and made the determination that that's probably not provable by a reasonable doubt. He's got a violation of probation, though, and as I've explained to him, the different burdens of proof, they're wanting to, when I say he's got a violation, this is where it gets weird. They're wanting him to plead to the violation. He's willing to do that. I've explained to him the different burdens of proof and how it all works. The problem is that I don't know, a VOP affidavit has been filed, but it doesn't look like it's been reopened for the VOP. And so I'm not sure how we want to proceed from here. He's ready, and he would be released today if he enters a plea. He's prepared to do that. It would be, or I say a plea, an admission on the BOP, and the state's recommendation was time served. I want to say he's got about 60 days in.
60 days from the date of the violation report. And I believe that VOP number is 21 CF 1978. There's a violation report filed, but it's not open on Benchmark.
What happened was he was arrested at first appearance. When he was first appeared on the new charge, they did an order commanding his arrest on the VOP, like a PC arrest without a warrant.
Okay.
So the first appearance judge had signed that back on 2/24/25. And
So for
the violation report, there's an order from a judge saying he's in custody for it, but it just hasn't really been restarted.
Judge, if the court wants, if we haven't been appointed on that, if the court wants to go ahead and appoint me on that, I'm prepared to proceed with entering an admission on the VOP, and then the state's going to announce a nollie on the new law violation.
373. And the basis of that failure to register was the defendant's grandmother's vehicle was at the same address he resides at. He had properly registered her vehicle with a temporary tag when she purchased it, but he did not update the registration when she got a regular tag on it. And he did do that as soon as law enforcement spoke to him about it to fix the tag with a permanent on it. So state at this point would announce a dismissal of 25 CF 373 in exchange for an admission in 21 CF 1978 with the 60 days OCJ to reinstate.
21 VOP case is not on the docket. There's an order commanding his arrest from first appearance.
If we need a little bit more time on it, what I'd ask is that the court consider giving him a bond on the VOP, so they can go ahead and be released today, and then just come back on Monday for the time-served sentencing on the VOP. Can you do that, sir?
I mean, giving him a bond on a case that's not, I mean, if it's not open, how do I give him a bond?
Oh, I see what you're saying. Well, we could,
Signed to agree to that unless there's going to be a plea today.
well, either way then, if this is the only thing that's handling him with the dismissal, he'd be released. I guess the question is, rather than having him get picked up again later on, do you want to just have him come back in?
We're only announcing a dismissal if he's entering an admission to the VOP that's not open.
Why don't we do this? Why don't we pass it while the Madam Clerk looks into it?
Okay.
To make sure, I mean, we can handle it later today. I just don't want it to be a situation where it's not open and it causes a problem because we did things in that case when it wasn't open. But the other concern is we do it and then for some reason that comes, looks like a warrant or something, he gets picked up later down the road because we didn't clean it up right. So, Mr. Copeland, we'll bring you back up. Let's just kind of finish this out, clean it up, and hopefully we'll be done this afternoon.
If anything goes south on that, Judge, I've got another case with you tomorrow, apparently. It's on the clerk's docket, although all my notices say next week. Let's see, gentleman's name is...
Mr. Williams, I don't have anything else on that docket, so I'd rather we put him on, try and resolve him for this afternoon.
We'll figure it out.
Gary is the gentleman's name, K.O. Gary. It's a return from Florida State Hospital.
That's set for tomorrow?
I I did a check for the docket because I'm just like that, and I saw it on there. Because sometimes we have stuff on Thursdays, and it would be my turn also for pretrial detentions if we had any. So I checked it, and the docket has got this gentleman's name on it, but looking at the order to transport and notice of hearing, it's got, well, yeah, it does have tomorrow. It says first day of May, so never mind. Yeah, he's on for tomorrow.
I do want to ask you a question about May 8th at some point before we leave today, so make sure we talk
Yes, sir.
about that. All right, who do we have now?
Let's see. Sorry, Judge, let me shuffle the deck here. All right. Joshua Douglas, Judge. Okay. Judge, this is another one that looks like it was Tim's. We've resolved some of the issues, but we still have an issue involving where we need to talk with the officer. So I'm going to go ahead and set the officer for deposition.
In which case?
Judge, I think this is going to have, would be the trafficking case.
Should be 24 CF 1226.
Yes, sir.
And the state is objecting to the continuance, Your Honor, because of, we've been ready for it. And I extended an offer. We received the FDLE that shows actually an amount that is higher than what he's currently charged with. My offer would be not to amend the information to reflect the higher charge, which will carry a substantial amount of minimum mandatory. Otherwise, I revoke that offer, of course, because
Judge, I spoke to my client about it yesterday. We made a counteroffer that the state has rejected. So if the court wants to leave it on for Monday, I'll certainly go out and talk with him again. And
This is new to you, Mr. Williams.
the case is new to me, yes, sir. I don't want him to lose the difference between a 7-year mandatory minimum and a 3-year mandatory minimum.
I'm more worried about the continuance in general.
Yes, sir.
So let's put it on for May 5th, plea or continue, noting the state's objection to any continuance.
Thank you.
All right, thank you, Judge. All right, I'll have to come out and see you again between now and then, okay?
I want cases to move just as much as anybody, but
Yes, sir.
can't do it with.
Okay, Judge, this should be Mr. Durden. Judge, Judge, I'm going to move to continue this one. We had information that the victim had filled out victim input form.
In which case?
Judge, in
24 CF 2762.
Yeah, 2762. In any event, in communicating with the state attorney, she indicates that she cannot find one in the file. I was trying to get it resolved. Mr. Durden was wanting to do a speedy trial, but I think that was based on the notion that the victim had come in and filled out a request for charges to be dropped.
Well, if I may, Mr., I wouldn't even be ready on the 24 CF 2762. The state is ready on 22 CF 2587. There is
Which
no.
you announced last time.
I know, that's
And
why.
I continued it over your objection last time.
I know it, Judge.
Judge, if we have to try one of them, that would probably be the the better one to try, looking
2.5
at.
years old, Mr. Williams.
Yes, sir. Looking at, it looks like deposition subpoenas went out at one point. Looks like in stack that depositions were taken. There was a note in there that the sound quality wasn't good. From what I've listened to, I'm able to hear it. So if I have to try one this time, that would be the one.
All right, let's put him down. That's Durden. 22 CF 2587. And we'll put the other ones to run along with it, the VOP and the new case.
Yes, Your Honor.
See y'all back May 5th for docket day.
Thank you, Josh. Okay, it looks like we'll get at least one of them done. Judge, this is Jalonga Dur. We did take depositions in the case. There were two witnesses that did not appear. One seems to be just in the wind. I don't think anybody knows where she is. The other is one of the male witnesses. He was actually the father of the children that the whole thing kind of arose around as a visitation between the two of them. The state's indicated to me that they've got a line on where he is and that he is here local, but I don't think we've gotten the new address yet. As soon as we get it, we'll reset that depot.
If I could say something, Your Honor, I would like to set this case for trial because, again, it's very, very old. For the deposition, if Mr. Williams has time, we can arrange it prior to the trial week.
Well, I mean, we only got a week before.
I'm sorry.
It's only a week.
Well,
It'd have to be next week.
for this one, I would also request the second week because the victim comes from out of state. We have to arrange travel. Or we could do it towards the end of the first week, probably.
Well, we can talk about that more on Monday. if
On
it's
Monday.
a Trial, but
Yeah.
this case is over 2 years old. as
Right.
well.
I would ask that if we're going to potentially try it, that either the state go ahead and make arrangements for the depot, since they've got a line on the witness, and there's no way for me to access the witness otherwise, and then be able to tell us when that's going to take place on Monday.
I can do that, Your Honor. I would certainly offer that solution. I wouldn't expect the defense to try to find the witness.
Mr. Durham, we're going to set your case for trial this time around. We'll see you back on Monday and see how this deposition pans out.
All right, sir. Judge, I've had a little confusion on this case, but I've spoken with some of the other attorneys that have had it since meeting with Mr. Dykes, and I'm going to meet with him again tomorrow morning. Generally speaking, images such as are alleged in this case, my experience is that they want both sides to look at them together. Apparently is not necessarily that way over here, because they're trying to minimize the number of times those images are viewed, the folks that handle these sorts of offenses. They feel like every time they're viewed, it's a separate.
My specific note from last time was the viewing of that evidence would be done prior to today.
Yes, sir, and it was not. I had a note about one of the other cases, Mr. Durham's case, but I've contacted the state about looking at, I mean, there's over 2,000 images, I think, 2,320 images that were taken off the iPhone. What I've asked to see are images that purportedly have him in it as well, and the movies, the video-typed images. as opposed to still photographs.
Well, I mean, there may be 2,000 images, but you've only charged a certain amount of them, right, Ms. Barrickman?
That's correct, Judge. And Mr. Williams did reach out to me yesterday about a lab visit, and I have sent an email to OCSO. Obviously, that was yesterday afternoon, so we're still trying to coordinate that. But it will just be of the charged images and videos. And any,
I don't think you have to view everything that hasn't been charged, which is typically how the state does it. It's usually 20 to 30 to 40 of them, even though there's 2,000 of them.
Yes, sir.
So what are you trying to do here, Mr. Williams?
Well, Judge, if we think we can get that done next week or the following, we could leave it on for the second week conceivably.
Because these cases are from July of '21.
I understand there's a situation with an expert, and I've talked with Ms. Rivers about that. Mr. Lewis had found somebody, and Mr. Sawicki, and then was unable to, I guess, get him to respond. Ms. Rivers came up with the idea of someone else. I'm still waiting on that name for her from her. When I asked her about it, she couldn't recall the individual's name off the top of her head. That's the only thing I'm thinking of that might further delay it. There's some issue with potentially a defense regarding how the images got onto his phone, and that's something that I think the expert alone would be able to answer for me. All I can say is I'll.
Has that expert been reciprocated?
No, we haven't had the expert retained as yet, Judge.
I have
And I know you just got on this case like a month ago, Mr. Williams, but this case is 4 years old.
Yes, sir, I understand. I understand.
I have notes from last June that John Sawicki was going to review the evidence, but I don't believe that ever occurred.
No, and my understanding is that.
It was my experience, and how this works is the experts in that meeting too. It's not just the defense lawyer comes and sees it, and then the expert comes later and sees it. It's.
Yeah, again, from what I'm understanding about what the situation is, the expert would be lending an opinion as to the validity of the images, whether or not they've been altered, of course. And I don't know what's involved in making that determination, but also answering questions from me about alternative ways that the images could wind up on the phone. And my understanding is that Mr. Zizwicki, I'm not familiar with the individual.
Is he local?
That was the person that was going to be their expert last summer. That's the last that I have in my notes as far as an expert reviewing for the public defender's office. Are you using him or someone else?
I don't, my last information is that Tim reached out to him and that he just kind of fell off the face of the earth, Mr. Zizwicki. He never got back to Tim. And so the decision was made by Lisa, was to try to find somebody else. And she came up with a name, but when I spoke with her about it, she was not with the file and did not recall the name off the top of her head. The only name that she had was Mr. Zizwicki.
What are you asking to do, Mr. Williams?
Judge, if the court and the defendant want to more closely monitor it, we can bring it in for call on Monday and see where I've gotten with it. Otherwise, I'd move to continue it.
I mean, I guess part of my concern is this is not the typical case of, a typical CP type case where there's also actual abuse charges as well, right?
There are, Judge.
In each of the two different case numbers.
Yes.
So, we've got alleged victims who have been waiting around for 4 years for the trial as well.
And they don't reside locally, so if we are going to set it for trial, I'd like to know that definitively this week so that we can coordinate travel. But if you're going to get an expert, I'd at least like a definitive timeline on when that's going to happen.
Yes, ma'am, and frankly, I would too. But I'll,
Can we set it P or C for Monday, and you can get the name of that person and get him on board or not on this case?
Again, I don't like the idea of continuing the case that's this old, but I know, Mr. Williams, you're new to it. You've got to get a lot of stuff going that you almost can't do in a month. So I'm not trying to give you any grief about it. I mean, we can talk about why this case was allowed to linger for years without seemingly these things being done. And I've already got...
we could also
And trials
schedule-
plus 4 or 5 more plea trials.
Yes, sir. How about this? How about I go ahead and move to continue it, and what we could do is schedule a case management conference where we just kind of touch base on where we are on everything on one of our Thursday pretrial detention days. With a case management conference, I know that Mr. Dykes doesn't want to come back and forth all the time, but with a case management conference as opposed to a pretrial conference, I believe he can waive his appearance.
Waive his appearance for a pretrial conference too. I mean, if that's what if you sign a written waiver, it's a pretrial court date. So, but I also don't want to put it on some random day unless Ms. Behrman, and I'm not going to have you show up for a pretrial detention docket unless you're going to be there.
We put it on a miscellaneous date before the next pretrial,
Why don't y'all figure out what date y'all would like on that?
June 3rd. Are you going to be available?
That's fine. Judge, he's just expressed to me he'd like to waive his appearance on that occasion.
Just have him sign something.
I'll send something over to the jail, you sign it, and send it back to me. Okay, yeah, I'm still coming tomorrow.
On June 3rd for kind of a status conference, June 24th for the next pretrial. Again, I'm going to need to see some real progress on getting this thing to trial the next time around.
Yes, sir.
I don't even like the idea of continuing it now, but for the fact that you've just taken the case over, Mr. Williams, and there's too much for you to do between now and a trial in a week and a half.
Yes, sir.
And Mr. Williams, just for your information, I have emailed the lab and asked for you to be able to visit with me to see the charged images and videos. But if you want an expert in there to see file paths and other things, you need to let me know. That will need to be put on a different clean computer for you to review.
Yes, ma'am, I would agree.
Okay, so let's get that figured out quickly.
All right, thank you, Judge.
All right, thank you.
Okay. Hey, come over here, Mr. Fernandez. Now, Judge, he had another matter with Ms. Dudley, but my understanding is that's already been dealt with a written
I believe
plea.
so, I remember that. All right, Mr. Fernandez, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Push that microphone towards him a little bit more.
Yes, sir.
It's fine. I kind of heard you. I just want to make sure that you're getting picked up by it. All right, can you state your name and date of birth, please?
Joe Fernandez, 9/19/98.
Okay, Mr. Fernandez, you're here in 1, 2, 3, 4, 5 cases. That's 23 CF 2758, where you're currently charged with burglary of a dwelling with assault or battery, which is punished by life in prison. Battery, which is a first-degree misdemeanor. Stalking, first-degree misdemeanor. Then you also have 24 CF 219, 24 CF 644, 24 CF 857, and 24 CF 1128, all of which are third-degree felony L&L exhibition. Do you understand all those charges?
Yes, sir.
All right, I've been handed a plea and sentencing agreement. The downward departure?
For, slightly, right? For,
It's lowest permissible is 72.3. This is for 60 months.
would you mind letting me look at that, because she might have.
I know
checked
one
it
was a
several times.
LIO.
Sorry.
That's fine, just let's make sure it's right.
Can I see the case? Look, I'm just verifying that the same cases are, he's pleading to.
Yeah, I've got
27.
27556 actually is the case number, where he's pleading to the LIO of just burglary of a dwelling.
Okay, that's what it is. That's what it is, Your Honor.
But I see I made an error on the plea agreement. That top case should read 23 CF 2756, not 2758.
Oh, yeah, that's why. Calculating.
Pretrial detention is tomorrow, right? What time is it at? Who's the person?
I got it, Judge, sorry.
It's okay.
Mr. William, so it was a burglary of dwelling, not with assault, so that brings it to level 7, 56 points, to a total of 106.4. We got to take out 20 points. 106 minus 28 gives us 78.4, times 0.75 is 58.8.
Yes.
That's where you got the 60, yes. Okay.
Yes.
So it is a guideline sentence?
So it is a
now?
guideline sentence.
Yes, sir.
All right, so Mr. Fernandez, what I have is the plea and sentencing agreement is that you plea as charged for all counts except for in 24 CF 2758, count 1, which was burglary of a dwelling with assault or battery, is going to be a lesser included of just burglary of a dwelling. Is that your understanding? Okay. And did you go over this plea agreement with your lawyer?
Yes, sir, I did. My public defender.
Okay, and did you understand and sign that agreement?
Sir,
Are you satisfied with your attorney's advice and representation?
it is what it is, sir.
Are you satisfied with your attorney's representation?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or
No, sir.
controlled substances? No. And are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
Not at all. No, sir.
Not at all, is that what she said? And has anyone promised you anything other than the terms of this agreement?
No, sir.
Understand by entering a plea, you're giving up your right to a trial and all the trial rights that are on page 2 of the agreement that you've signed.
Yes, sir.
You understand that there won't be, that you're waiving all potential defenses that you have to each of these charges.
I understand, sir.
You understand that if you're not a U.S. citizen, you could be deported because of this case.
Yes, sir.
All right. And as to 23 CF 2758, what is your plea to the battery, the stalking, and the lesser included burglary of a dwelling?
No contest, sir.
Okay, and the 4 other counts, and that's 24 CF 219, 644, 857, and 1128, the L&L exhibition. What is your plea to those 4 counts?
Yes, sir.
All right. And your understanding is that it's a 60-month Department of Correction sentence, correct?
Yes, sir. May I ask a question?
Yes, sir.
Will my time served?
You'll get credit for all your time served, yes, sir. Any other questions?
I forgot the day I came to jail, so I'm kind of.
They'll figure it out for you, and then
seeing it.
if you have any concerns with if it's accurate or not, you can always come back with what's called a 3800B motion and ask for it to be recalculated.
Okay.
It's pretty rare that they usually get it right down to the day pretty well. So,
Yes, sir.
in fact, it usually takes me quite some time to figure those things out because I don't have the program that they do. I'm just kind of doing it all by hand, but you'll get all credit for time served on each of your cases. Any other questions?
No, sir.
Okay, then I'm going to accept your no contest plea. As to the counts as discussed, I'm going to adjudicate you guilty on each case, each count. It's going to be on the 23 CF 2758, count 2 and 3 are misdemeanors. Those will be time served.
Yes, Your Honor.
Okay, and on the burglary count and the 4 other counts, that'll be 60 months Department of Corrections with credit for all time served. Each case is going to be $515 court costs and $150 PD fee. I'll send those to collections unless you want to try and set up a payment plan upon your release. Collections. All right, those will be sent directly to collections. You've got 30 days to appeal the judgment and sentence of this court, Mr. Fernandez. I'll need you to be fingerprinted before you leave.
Yes, sir.
2758. 56, okay. All right, it's 56 up here, but it's 58 down there, so I'll just change it on the form.
Yes, sir.
I apologize for that, thank you.
Yes.
All right, and this is a guideline sentence due to the change in the burglary charge. Guidelines were now, where'd it go? 58.8, and this is 60 months, so it is a guideline sentence. All right, thank you, Mr. Fernandez. You need to be fingerprinted.
All right.
Good afternoon.
Afternoon.
Judge, this is Jared Fountain. I did
No,
a
it's
bond.
Anthony Firestone.
Firestone?
Yes. Anthony Firestone.
I don't have a
I think you have a fountain is next week is that's the bond hearing I need to talk to you about.
Yes, sir. Well, that's what I was going to tell you. If I'm not familiar with a Firestone, Judge, give me a minute and let me pull it up on the computer.
Okay. I'm trying.
First, who's representing you.
Okay, no problem.
Madam Clerk, are you showing that notice of appearance was filed by me?
All right, I'll take a look at it as well, Your Honor.
He's saying Firestone, F-I-R-E, like the
Like the tire.
business?
I think,
like the tire
that
company?
the error here might be, Mr. Timothy Gibbs was representing me at one point. And I believe he's no longer here.
He's no longer in this
Right,
division.
that's the issue.
And that's what, we're just trying to figure out why it says it's assigned to Mr. Williams when he doesn't seem to know that.
I understand, yes, sir.
Where it was assigned to Mr. Maddox just recently, and then I can see the same thing. It's all of a sudden it just says J. Williams, but it doesn't say why.
In our system, he's not showing up in my service, so I'm going to pull him up and see whose service he's showing up as being in.
What's the first initial, sir? First initial, your first
A,
name?
Anthony.
I can give you the case number if that will help you.
I should be able to find 24 CF 2063.
Yes.
All right.
It's a possession and felony DUI.
How old is it? Honestly, you've
10:30.
forgotten more about DUIs. Yeah, he wants to plead like 6 months.
State have an offer in his case currently?
Or did you say
It's a
6
third
months
degree
community
felony, so I'm
control
surprised
or
it's
6
Mr.
months
Williams'
county
case.
6 months county jail, run concurrent with all credits. I'm sorry, I would plea out right now.
Okay. Well,
If it would be. Unfortunately, I do. If the state would agree to that, I would very much like to.
Can you come in? We can.
Yeah, I'm showing.
ECLC.
Yeah, you've got statutory requirements on a DUI. I can,
Sir, you're represented by counsel, so you talk to your counsel, and you're not going to negotiate it over his. Okay.
Points. It doesn't score minimum.
case.
So, Your Honor, if the court's amenable to it and if the state had no objection, I'd like to put him on the 5-5 docket for plea or continue. We're going to discuss the plea, the specifics of the plea agreement, go over all the terms with him, and if he's amenable to taking that, that's certainly fine. Obviously, today, Your Honor, I just don't know enough about the case to say whether that's good or bad, but certainly we can talk to him about the plea agreement, go from there.
Understanding this would be a third DUI in 5 years.
Third within 5?
It should be within
Felony?
10, Your Honor.
I understand that the statute is
Third
third
within
within
10,
10, but
sorry.
the priors are both within the past 5 years. So,
Understood, Your Honor. And again, either once we get sorted out who will be representing him, either I or Mr. Williams will certainly go out and see him before the 5th, again, if the court were amenable to that.
May 5th, plea or continue.
Thank you, Your Honor. All right. one of us go
Thank
see
you,
him.
guys.
So we'll get that figured out. One of us will go up and see him.
Okay, Mr. Fountain?
How you doing, sir?
Doing all right. Judge, this is the one with the basically two issues, DV, another issue involving an officer. I think we've got the DV situation part of it taken care of, but.
It is, the battery on law enforcement, okay, go ahead.
Yeah. So what I want to do is take the officer's deposition in it. Right now, the offer is DOC. He's been accepted into Haven House in Chrome, and so we might be able to work it out for that if the state was amenable, but I don't think the state's amenable at this point.
Well, I would have to communicate to the victim, Your Honor, if they're willing to do a downward departure and, 'cause, if I may, I can try to speak with the officer before Monday and have an answer on Monday.
I'm good with that, Judge.
And it looks like Mr. Fountain is set for a bond hearing on Thursday, the 8th.
Yes, sir.
I'm not going to be here that day. Someone else is going to cover the arraignment docket. So if that changes, if you want to try to, if you don't figure it out on Monday, if you want to maybe do the bond hearing on Monday too, since you're going to be talking to the alleged victim anyway, I'm just not having 3 court dates within a week.
Yes, sir.
And plus, it's going to be a different judge here that day.
I'll be fine with Monday, handling both, if, yeah.
Yeah, I'm fine with doing that on Monday, I think. You're not, the domestic violence case is not an issue on the bond situation as well. So I won't need to have her here to testify at the bond hearing. So that eliminates my problem that I might have had otherwise with Monday, is just getting her in.
Right, no,
Okay, so yeah, we can do all that on Monday, Judge.
and honestly, at the end, if you need witnesses on Monday that you don't have and you want to anyway have it heard on the 8th,
No, I think she was the only issue.
okay, that's fine.
Okay, and that's the only case that's set on the 8th other than the arraignment docket. So
yes, sir.
Again, it's not going to be me, so I'm not going to
Yes, Your Honor,
say
we'll
who
do
it
the
is at
best.
this point, but it won't be me.
Yes,
So if
sir.
y'all want to resolve that, then.
Yes.
We're going to do your bond situation on Monday as well. She's going to talk to the. And I'll come out and talk.
Does the state know who would be handling pretrial detentions next week?
Me.
On your rotation? Okay.
It's always me, Your Honor, only if I'm not
Sorry, Rita,
available,
thank you.
someone else
Okay.
covers. Yes.
Come on up, Ms. Gaines.
Thank you. What about the PD's office? Y'all rotate?
Yes, Your Honor, we
pretrial
rotate.
Do you know who has next week?
I could figure it out for you.
Okay. Let's talk about that before the end of the day.
I think it's going to be Lisa. I know I've got it, at least I think I've got it this week. That was my recollection. All right, Judge, this is Ashley Gainey. It's going to be a negotiated plea.
And we're not going to have the motion to suppress?
No, Judge, we're not, although I'm going to probably share it with the state. I think there's a wrinkle to the statute that I need to make everybody aware of. I do have it
What did that have to
drafted.
do with
but-
leaving a parking lot or something like that?
She was leaving a convenience store, and the question was stopping at the, before entering into the roadway. But when you look at the statute, it actually differentiates between a residential district, business district. It doesn't say just business.
I didn't read it like that. Well, anyway.
I mean, if there's a plea, there's a plea. I just know Ms. Gainey was really wanting to have that heard, but it sounds like y'all have at least talked about it and resolved it in some way.
Yes, sir.
All right, Ms. Gainey, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Ms. Gainey, you're here in 24 CF 206, where you're currently charged with trafficking in methamphetamine and trafficking in fentanyl, which are both first-degree felonies punished by up to 30 years in state prison, and also possession of drug paraphernalia, first-degree misdemeanor. Do you understand the charges as they are right now?
Yes, sir.
Okay, I've been given a plea and sentencing agreement that calls for you to, on the trafficking charges, plead no contest to the lesser included offense of sale, manufacture, or deliver, or possession with intent, methamphetamine and fentanyl, which would make them, what, second-degree felonies then?
Yes, sir.
Okay,
Yes,
we'll
sir.
agree on that. Second-degree felonies punished up to 15 years in state prison. And then, as charged as to the paraphernalia, is that your understanding what you'd be pleading to?
Yes, sir.
Okay, and from my reading of the agreement, it's adjudication of guilt, 24 months Department of Corrections with credit for time served, followed by 3 years probation with ECLC or similar program, random year analysis. That would run concurrent between the two felony cases and be time served as to the misdemeanors. That's your understanding?
Sir.
Okay, and one of the reasons I wanted to make sure we talked about what level the sale, manufacture, delivery charges are is if you were to violate your probation, those are each punished by up to 15 years in state prison instead of the 30 that they are as at the trafficking level.
Okay.
Okay. So obviously, if you do your time and get out and do your probation with no violations, then you don't have to worry about that, but I have to make sure you understand it. All right. Have you gone over this plea and sentencing agreement with your attorney?
Yes.
Did you
sir.
understand and sign it? Yes?
Yes, sir.
Okay. And are you satisfied with your attorney's advice?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand that by entering a plea of no contest, you're giving up your right to a trial, and all your trial rights would start at the very bottom here of page 1 and go on to page 2 of the agreement you signed? And you understand you're waiving all potential defenses that you may have?
Yes, sir.
And you understand that if you're not a U.S. citizen, this plea could lead you to your deportation? Okay, got to say it to everybody. Got a lot of smiles about that today, so. All right, and this is the state's agreement,
It is, Your Honor.
and due to the reduction in charge, it's a guideline sentence because she doesn't score with the reduction?
I believe so, right?
Yes, I got it as
Yes,
40
sir.
points.
Yes, yes.
Okay. All right, and what do you plea as to the lesser included 2 counts of sale, manufacture, deliver, and the paraphernalia?
Contest.
Okay, I'll accept your no contest plea to each of those counts as reduced. Counts 1 and 2 would be adjudication of guilt, 24 months Department of Corrections or credit for time served, which you got over a year in, right?
Yes, sir.
Okay. Followed by 3 years of probation with Emerald Coast Life Center or similar program, random year analysis to detect the presence of controlled substances or drugs that you're not supposed to be using. That will run concurrently between those 2 counts, $615 court costs, $150 in PD fees, and then count 3, the paraphernalia is just adjudication and time served. So I need you to talk to probation, even though you've got a DOC sentence, you got to talk to them before, so you have some guidelines as to when you're released. I need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court.
All right, Ms.
thank you,
Gainey,
Ms.
good
Gainey.
luck to you.
Good luck with everything. Yes, cost supervision will be waived based on the fact that she's represented by the Public Defender's Office.
Mr. Rivers has PTDs next week, Your Honor.
Okay. I just may want to talk about how we want to handle those since it's going to be a fill-in at that point, so.
Sure, I'll let her know.
If she has any preference on just send them to the south end, I can talk to Judge Stone and Judge Clarko handling them, or just have the fill-in judge do that.
Judge, this is Gerald Hagens. This one's going to be a little bit more complicated. We've got a negotiated plea in our cases that ultimately Mr. Hagens is inclined to accept. He's got some pending Santa Rosa cases that I talked with his public defender over there and had worked out. We then discovered that he's got a serious warrant out of Santa Rosa County, a trafficking warrant. He does not want to resolve his cases until he has gone to Santa Rosa and has been in a position to try to work everything out concurrently, where he basically knows what he's going to get sentenced to, and he knows how everything's going to work. So the only way that I can figure to make that work will be to get Santa Rosa. I know they're not going to want to serve the warrant on him until they get him over there. To get them to do a motion order to transport him over there. Then they can serve the warrant on him, and I'll coordinate with his public defender over there in terms of trying to get all this resolved. You'll actually wind up with a different PD because it's a more serious charge.
What's the warrant for?
Trafficking, Judge. Hang on a second, I can give you more detail on it.
That's fine, that's enough
file.
information. What would you like to do today?
For today's purposes, I guess, move to continue it, and obviously I'd ask of the court, when you get the motion order, it'll be from Santa Rosa County judge, but certainly let it go through.
I'm not sure what you're referring to.
Well, I'm going to tell my counterpart in Santa
Do
Rosa.
a motion in order to transport him over to Santa Rosa?
Yes, sir, to do a motion order transporting to his county, to Santa Rosa. Once that happens, he'll be in their custody. They'll go ahead and serve the warrant on him.
And then what will most likely happen if the cases don't resolve at our next court date, I'm going to issue a capias to make sure he gets back.
Make sure there's a hold, yes, sir. But that'll get the ball started with getting everything worked out together.
Any issues with the state?
No, except that now our cases are going to be very, very old until he tries to resolve the Santa Rosa. I
The case is already
understand.
very old. I mean, the
One is from
one case is
23.
from October of '23.
But obviously, I cannot foresee everything that might happen in the future, but as best I can represent, this is not going to be a trial.
What's the agreement at this point? Had it not.
Oh,
been for
it's
Santa Rosa?
for some time, Judge.
Sometimes he's facing a minimum mandatory. I agreed to do guidelines without the minimum mandatory to be concurrent with whatever other sentence he was going to serve.
And right now, his offer in Santa Rosa is 36 months, but they were going to run it concurrent with what he's got over here.
No, I think that
Oh, and the warrant is for possession of a weapon by a convicted felon and trafficking in fentanyl greater than 4 grams.
Potentially two different 3-year min-mans?
the fentanyl will be 7 years min-man, that amount. Yes, yes.
And it's not saying, obviously.
I know if it's not the actual possession and it's constructive, it's not the min-man, but.
Well, it's also saying weapon as opposed to firearm. So, and obviously, he's going to try to negotiate something that will work with what the offer is over here. But getting him over there is the first step to getting all this done. Unfortunately, other than maybe my drafting it for the PD and sending it over there for the PD to put his signature line on, I'm kind of limited in what I can do.
I can put it on the next pretrial, but I'm not going to just keep hoping they do something about it over there.
Yes, sir. I'm hoping that it'll all, since he's got a prison sentence already pending, I'm hoping that they'll move quickly to get it resolved.
All right. I'll put it on June 24th, but I expect, Mr. Hagens, you'll be in Santa Rosa by then. to resolve those cases.
Yes, sir. Thank you, Judge. Judge, this is Robert Clyde Henderson. I had an evaluation done on him, and it came back as competent. I've talked with the state about trying to get him into Keaton or someplace like that. I don't think I've got an answer on that with regard to Mr. Harrison as yet. But that's what we're trying to do. He was determined by Dr. Zeman to be competent as opposed to intellectually disabled, which is part of the issue that we're dealing with. But that was my concern. Now, I did meet with him again and had no problems communicating with him or anything like that. Okay. You want me to have this, sir?
Yes, sir.
All right.
Thank you.
What are you looking to do today, Mr. Williams?
Do you happen to have an answer? Or do you think you might get one relatively quickly on whether or not you'd be willing to go with?
No, I know I'm not willing to go due to the nature of the offense, the great bodily harm, and the victim's concerns.
All right, Judge. Both of the cases are from 2024.
They're not old. They're
And we've got some potential mitigation as a result of the evaluation. I'm going to go ahead and just ask to continue it for right now because we've got things kind of stacked up anyway next week. But I'll talk with the state attorney some more, and if not, it may be one that'll be a straight-up plea.
There is no objection, Your Honor, to continue.
I was just looking, I saw the name of the alleged victim, which I know someone by that name, but in continuing to read it, it's not that person, so.
Yes, sir.
All right, so 6:24 at 9 o'clock.
Thank you, Judge.
Thank you, Mr. Harrison. We'll see you back then.
All right, sir.
Thank you, sir.
Come over here, Mr. Horn. Judge, this is a case where we did a motion to suppress on it that the court denied. I talked with the state attorney about potentially stipulating that the motion was dispositive, and then went out and talked with my client about potentially entering a plea to the offer, reserving the right to appeal with the stipulation. He's not happy with my services. I think I don't think he's filed anything in writing, at least not that I've seen. But it may be that we need to do a Nelson inquiry on him. Do you intend to ask the judge to remove me and have somebody else appointed?
Not at this time.
Okay, all right then. Do you want me to go ahead and get this on the trial docket, try to get it resolved, or come out and talk with you again about reserving your right to appeal so that we can appeal it without you going to trial? Do that?
Yes, sir.
All right, let's leave him on for Monday. I'll go out and see him again, Judge.
Okay, but plea or
Subpoena?
continue, or?
Well, Judge, what I'm going out to see him for Monday for is potentially to enter the plea, reserving the right to appeal. So I'm going to say plea or continue.
Okay. I just want to know what I'm putting on. So.
Yes, sir.
All right, plea or continue, that's going to be, we'll see you back on Monday, Mr. Horn.
Sir, thank you.
Thank you.
Judge, this is going to be, I've got either 2 or 4 that are, they're negotiated pleas, but because of the timing involved, I didn't get it nailed down until this morning, so, well, actually, in Mr. Hudson's case, he signed last night on our proposal. All right, so what I've done, Gary, is I've written in the state's counteroffer up here for the 1129 County Jail with credit. I need you to initial that.
Okay, what?
Initial it up here.
Up here?
Yes, sir.
Is that credit time served too?
Yes, sir. Yes, sir. You always get credit for time served unless you specifically waive it. State's already signed it, I've already signed it. Modified our counteroffer, or the state made a counteroffer.
All right, so it's adjudication 1129 with credit for time served?
Yes, sir.
Fees. But it's still to the felony. Is this a guideline sentence?
It is not, it's a downward departure, Your Honor.
Okay, what is he, do you have the guidelines?
Yes, I got one getting printed out. and
Okay.
Ariana's grabbing it. His lowest permissible is 34.875.
So obviously it's uncoerced plea bargain is the reason for the downward departure?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Mr. Hudson, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I'll do, Your Honor.
All right, can you state your full name and date of birth, please?
Gary Lee Hudson, 52169.
All right, and Mr. Hudson, you're here in 24 CF 2235, charged with a third-degree felony of misuse of the 911 emergency system. Do you understand that charge?
Yes, sir.
All right, I've been given a plea and sentencing agreement that calls for you to be adjudicated guilty, which would make you a convicted felon.
Yes, sir.
11 months, 29 days in county jail with credit for time served, $515 in court costs, and a $150 PD fee. Is that your understanding?
Yes, Your Honor.
All right. And, yes, sir. And that's the state's agreement?
It is, Your Honor.
Okay, and it's a downward departure again based on that agreement. All right. Mr. Hudson, did you go over this agreement with your lawyer?
Yes, Your Honor, I did.
Did you understand and sign this agreement?
Yes, Your Honor.
And are you satisfied with your attorney's advice?
Always. Very pleased.
Okay. And are you currently under the
I
influence
think
of
he needs a raise.
alcohol? Say again?
I think he needs a raise.
I don't have control over that, so.
Yeah, we'll take the raise.
I think the state needs a raise too.
Hold on just one second.
Yes, sir.
All right, so where was I? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, no, sir.
Okay, are you currently suffering from any mental health issues?
No, no, Your Honor.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Anyone promised you anything in return for your plea?
No, Your Honor.
Do you understand by entering the plea, you're giving up your right to a trial and all the trial rights which are on page 1 and continuing to page 2 of your agreement?
I do, Your Honor.
And you understand that you're waiving any potential defenses that you may have?
Yes, I do, Your
Do
Honor.
you understand that if you're not a U.S. citizen, this may lead to your deportation?
Yes, sir, Your Honor.
All right, and what is your plea to the misuse of 911?
Contest, Your Honor?
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, sentence you to 11 months, 29 days in the county jail, credit for time served, $515 court costs, $150 PD fee. As far as those fees, just send them to collection or judgment, Mr. Williams?
Yes, Your Honor.
All right, that'll be sent to judgment.
Thank you.
All right, you have 30 days to appeal. You need to be fingerprinted on your way out, Mr. Hudson.
All right, Mr. Johnson, I got that typed up for you. The state agreed to it. Okay. There you go. So, Judge, the state accepted a counteroffer that we made. He's signing it now. Do you mind if I date this for you, sir?
No, I don't mind. I get credit for all time served, too?
Yes. Yeah, you have to specifically waive it not to get credit. Every once in a while that happens, okay? But if nobody says anything, you get credit. And did you do?
Thank you, sir.
Oh, wait a minute, I don't know that I got the state to sign it.
Well, I do sign yours
You did,
normally.
but
Yes.
Cody didn't.
Oh, now someone signed it. Where is my place? Oh, here.
Down there.
I sign it, I don't need.
Okay,
Yeah.
I'll remember that next. Stack of blank checks.
All right, Mr. Johnson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Johnson, you're here in 23 CF 168, which is a violation of probation, and you also have 24 CF 2471, where you're charged with false imprisonment, a third-degree felony, and battery domestic violence, a first-degree misdemeanor. I've been handed a plea and sentencing agreement for 24 months DOC on each of the felonies, and on the misdemeanor time served, revoke and term your supervision on your probation, $967 in court costs of prosecution, and PD fees. Is that the agreement that you've read?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Did you go through the agreement with Mr. Williams?
Yes, sir.
Did you understand it?
Yes, sir, I did.
And did you sign it?
Yes, sir.
Sorry, I think I asked you the same one twice. It's about the 50th time I did that today.
Yes, sir.
Or done this today. All right, and are you satisfied with the advice and representation from your lawyer, Mr. Williams?
Yes, sir, I am.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
All right, so this is another downward departure?
Yes, Your Honor.
Yes, sir.
I'm sorry, if you enter a plea, do you understand that you're giving up your right to a trial and giving up your trial rights, which are on page 1 and 2 of the document you signed?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that this plea, if you're not a U.S. citizen, can subject you to deportation?
Yes, sir, I do.
All right, so as far as the VOP, do you admit or deny your violation of probation?
Yeah, I meant.
Admit the violation of probation. As far as the new charges of false imprisonment and domestic violence battery, what do you plead?
No contest.
All right, I'll accept your admission to the violation of probation and your no contest plea to the new charge as freely, voluntarily, knowingly given. On the felony counts, it's going to be 24 months Department of Corrections. On the misdemeanor battery, it's going to be time served, revoke and terminate your supervision. On the probation case, total of $967 in court costs of prosecution, and PD fees. You'll be adjudicated guilty on each of those counts and cases. You've got 30 days to appeal the judgment and sentence of this court, and you need to be fingerprinted on your way out, Mr. Johnson.
Yes, sir.
All right, good luck to you.
You too, right?
Cost of collections. Thank
I
you.
can send you a letter.
Yeah, that's fine.
All right. Thank you.
Judge, if you give me just a second. All right, Judge, sorry, he was asking me about a misdemeanor DUI that he has. I'm referring him back to Mr. Hall on that. So what we have is a negotiated plea for on count 1, lesser included, of resisting arrest without violence. Count 2 as charged, that's a little second-degree misdemeanor, be an adjudication of guilt, 1 year probation concurrent, 1 year probation on fleeing and attempting to elude. It'd be 6 months concurrent on the,
Well, that's going to be resisting without, right?
yeah, resisting without, I'm sorry, Judge. Yes, sir, resisting without, first-degree misdemeanor.
And Mr. Barry's going to be a stickler and tell me it's going to be 11 months, 29 days probation.
Let me get your signature up here.
So this is,
Yeah, this will take care of your cases up here, but what you're asking for on the DUI is not a legal sentence, so I can't get it for you.
okay.
There's a way to do it, but this court's not going to do it that way.
Sorry, I'll read it real quick.
Yeah. If you want to spend more time with it, we can have you come back on Monday.
Just, can I ask you a question real quick?
Well,
I'm sorry. I'm just a little slow. What do I sign?
Right there. All right. You mind if I date it for you?
Sure. I asked if they had heard anything going like that.
Yes.
Okay.
All right. Get your signature on that. And Judge, since these are 2 misdemeanors, there won't be a need for a
Score sheet. Have we figured out anything on that? That Copeland thing yet?
There you go.
All right, Mr. Mills, can you raise your right hand?
Yes, sir.
You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Mills, we're here in 24 CF 2340, where you're currently charged with fleeing and attempting to elude a third-degree felony punished up to 5 years in state prison, and leaving the scene of an accident, which is a second-degree misdemeanor, punished up to 60 days in county jail. Do you understand that?
Yes, sir.
All right, you can put your hand down.
Yes, sir.
All right, and Mr. Mills, I've been given a plea and sentencing agreement that would have you pleading no contest to the lesser included offense of resisting without violence on count 1, and count 2 would be as charged. It calls for a withhold of adjudication, 11 months, 29 days of probation, concurrent. Well, I guess it would have to be 6 months concurrent on the second degree.
Yes, sir, on the second one would be 6 months.
All right. So 1129 probation on count 1, the resisting charge, and 6 months concurrent probation on count 2. What would that, is that 270 or is it 300 because of the leaving the scene? $300 in court costs and then $100 PD fee.
Yes, sir.
So that can be paid during the course of your probation. Is that what you want to do today?
Yes, sir.
All right. Have you gone over this form with your attorney, Mr. Williams?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And are you satisfied with his advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Sorry, I'm just getting a little parched. Has anyone forced, pressure, or threatened you in any way to get you to take this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
Anyone, I'm sorry, if you understand that if you enter this plea, there won't be a trial of any kind, and you're giving up your trial rights, which are listed out in this agreement? Okay, you understand you're waiving any potential defenses that you may have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
State's agreement?
Yes, Your Honor. I think one clarification, I think leaving the scene is $303.
303, not 300?
So we are
State radio fee. Okay,
I
$303.
don't even try on the traffic cases anymore, Judge. I just send it to the clerk.
Well, I guess I could say, back when I practiced, I would go up to the clerk ahead of time on a plea and say, what are these going to be, so I can put it on my plea form? But you've got a lot of cases you're dealing with, and they're all new to you, Mr. Williams, so I'm not sending that to you.
Still fresh from misdemeanor, Your Honor.
Yeah. All right, so, Mr. Mills, what is your plea to the resisting without violence and leaving the scene of an accident?
No contest, sir.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Withhold adjudication, 11 months, 29 days probation on count 1, 6 months concurrent probation on count 2, $303 in court costs, and a $100 PD fee. You're going to have to talk to probation before you leave here today, and you have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
Thank you, Josh.
Thank you all. Bless.
All right, good luck, sir.
Yes, sir.